Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am joined today, luckily for me and for you, by two excellent colleagues. To my right, Justice Henry. To my left, Justice Wood. We will be hearing 6 cases this morning, and we'll take a break after the third one. The rules of argument here are maybe well known to many of you, but they are 15 minutes per side with no rebuttal. We have read the briefs with some care, so you may want to just get into your argument rather than spending what limited time you have on the facts, but it is your time and you can use it as you will. And with that, the first case is ELFERS R.R.H. Limited versus ELFERS R.R.H. LLC. And we will hear first from Attorney Ryder.
May it please the Court. My name is Stephen Ryder, and I represent the appellant and plaintiff in this case, ELFERS R.R.H. Ltd. Now, since the plaintiff and the defendant have nearly identical names, if it pleases the Court, I'm going to call them plaintiff and defendant, because...
Well, why don't we use something like partnership and LLC? Can we do that?
That's fine. We can use
Okay,
partnership and
I know you guys
LLC.
had a difference of opinion about how to label them, but for now, let's try that. Just because
That works
plaintiff
fine.
and defendant may get
That works fine.
more
I just
confusing.
didn't want to call them ELFERS.
No, of course.
For obvious reasons. So my client is the partnership. The defendant was the general partner of the partnership for almost 40 years. And our basic argument about why this court has personal jurisdiction over the LLC is this. This case arises from a contract signed in 1978, and breaches of that contract and breaches of fiduciary duties that arise from that contract. And there is no serious dispute that that contract was transaction of business in the Commonwealth of Massachusetts. The history, which is laid out in significant detail in both of the papers, is that the partnership, my client, was organized in 1977 by a fellow named Curtis down in Florida, who wanted to build a relatively small but a subsidized low-income housing development. To do that, he not only needed a loan from the government, but he needed some significant equity. $325,000 in this case. So
Sorry, we know the facts. Can I jump to the end? I hate to do that.
Yes, please.
But so you guys, the folks you represent now, the money people, are the people with 95% interest, are in Oregon. They're not in Massachusetts anymore. Your core of your argument was when this bad behavior was happening, Curtis et al., in Florida, the money people, the partners, the 95% interest, were all Massachusetts people. But that's no longer the case, although the fraud or whatever it was happened when they were. And so that's the basis of personal jurisdiction. That's the core of it, right? Does it matter that now, because they say it does, so really I'm saying respond to their argument that, look, it doesn't matter what they were, who was. It's now Oregon people. So why are arguing about Florida people? Massachusetts is out of this now. Why should Massachusetts courts be dealing with this?
Well, Judge, I spent a lot of time looking for a case that would address that specifically. Here you have a situation where the Massachusetts entity, Wright Stone, which was owned by Neil Brown,
Yep.
And was the 94% owner, while these breaches of fiduciary duty took place. After he finally got control through litigation in front of Judge Davis in the business court, finally got control and audited the books, he finally found out about this. Then in 2021, was by that time aware of these causes of action. In 2021, he then has sold and assigned all his interests to a company called Inter-Pacific in Oregon, which their mission
is the current plaintiff partnership, right?
They're the limited partner of the partnership,
Yep, right.
and also control the general partners. So they're in control.
Right, but so I will actually say to both parties, it might have been helpful had you made a map of these entities, because you've left us all to do that, and hopefully we get it right.
Sorry.
But one of the questions that's not clear from your briefing is, at what point in time are we considering whether there was jurisdiction in Massachusetts? Because is it the day the complaint is filed?
I think that is the rule, that you consider the jurisdiction. And what I was going to finish saying to Justice Wood is the way I looked at this was that when the Massachusetts entity sold its interest, it also assigned all its rights and interests, including its causes of action against the defendant.
And is that in a contract or somewhere in our record? Because that was actually another question I had.
I think it is. I think those documents are there.
But this isn't a derivative action, is it?
No.
So who cares what their interests are? The partnership's interests presumably don't change at all.
Right.
Partnership exists, and it has causes of action, and rights, and whatever else it has. And the fact that the equitable interests in the partnership are being bought and sold shouldn't affect that.
Well, that argument is another one. That would certainly suggest that the transfer of the limited partnership interests wouldn't necessarily have a bearing on this, because the plaintiff is the partnership itself.
Do you have a case? So let's say that, accepting that the malfeasance, the breach of fiduciary duty happened while the partners were in Massachusetts, and that, do you have a case that establishes that, and let's say that moment is the relevant moment. Well, first of all, do we have a case that moment is the relevant moment? And is there a case to establish that?
I couldn't find that in a jurisdictional case,
Okay.
where they were talking about, particularly where they were talking about a subsequent litigation by an assignee, whether that's what they particularly
Right,
look
so
at.
even putting aside the complicating factor that now the assignee is no longer a Massachusetts-based company, there's not even a case that addresses that initial situation where the partnership was Massachusetts-based.
Well,
Tetro. What?
Yes.
Tetro. I'm struggling. It seems to me that Tetro is helpful to you. Talk about Tetro.
Well, the cases that I think the cases are pretty clear, and this is why I started out on this point, is that if the breach, and this is, I've cited Judge Young's opinion in my reply, that when you're looking at jurisdiction questions, particularly under 3A, so you're saying did it arise out of transacting of business in Massachusetts? You're not looking at whether the breach itself constituted a transacting of business. You're looking at whether the contract, which is allegedly breached, constituted a transaction of business in Massachusetts. And I don't think there's any question here that under the myriad of cases that the basic contract, the partnership agreement, which governed the conduct of the defendant of the LLC, pardon me, as the general partner. There's no question under the cases that resulted from a transaction of business in Massachusetts. I could go through the facts that lead to that, but I don't think there's any serious dispute that if this case had broken out in 1990 or even 1995, or 1980, I'm saying. It's signed in 1978, so if the case had broken out in 1980, 1985, even 1990, everybody would have said, well, yeah, it's arising from a contract that resulted from this Curtis soliciting Boston Capital and raising money and the 94% investors. I don't think there would have been any question. And just because there has been many, many years passed, including in that several years while my client was trying to exercise, not my client, Wrightstone was, my client at the time, was trying to exercise its rights to replace the general partner. Just because you have that lapse of time doesn't mean that the contract loses its nature as a contract that was created through transaction of business in Massachusetts.
So,
and what
but
Judge Young says
at the time of the malfeasance, what was the connection to Massachusetts? Is it just the contract, or is there more?
Well, it's a contract, and then the malfeasance in part involved lying in the financial reports and lying in the various documents that were mailed to Massachusetts. They took, for example, one of the most glaring is they took a $9,500 a year partnership management fee that was paid out to one of their affiliates, Jotar. And there's nothing in the partnership agreement that allows them to do that. In fact, there's a different fee.
What was the last year that a Massachusetts anything held, a Massachusetts resident, but of any of these entities, held any interest in the partnership?
2021.
Okay.
That's when it was sold to the Oregon.
The briefing says Wrightstone, Inc. was dissolved by our Secretary of State in 2019, and I assume it went somewhere because in 2021 it sold to the Orangewood Lakes people, and if it didn't exist, I don't know how it did that.
It was dissolved by the Secretary of State for not filing annual reports, and so it can, what the law says in those circumstances is it certainly can revive itself, but it didn't in this case. That the corporation doesn't just disappear, that it has assets, and it certainly can engage in activities liquidating its assets, and that's what this was.
So where do you think the center of gravity of this dispute was?
The center of gravity, I think, is with the Massachusetts, was originally with the Massachusetts investors who were defrauded and who have assigned their claims to the new owner, the Oregon investors. That's really that's what I think.
So the fact that, they're going to get up and say, look, the defendants are Florida people, Florida citizens, the LLC is based in Florida. This is all about a project, a housing project in Florida. And now, and while yes, there were investors in Massachusetts, now we don't even have investors in Massachusetts. We now literally have no connection to Massachusetts, but they're going to say the center of gravity always was the people who run the place, the people who conceptualize the place, and the place itself all in Florida. How can that not be the center of gravity? What's your answer to that?
Well, because I would suggest that the fraud that took place and the misrepresentations were all done in Florida and sent into Massachusetts to basically prevent the Massachusetts people from finding out that they were being robbed. And then they fought in front of Judge Davis for 4 years. It wasn't all in front of Judge Davis, but it took 4 years for us to finally get control and get the books and records. And that's when we finally were able to discover that these misappropriations.
I'm sorry, where is this center of gravity test? I thought we were talking about personal jurisdiction.
Yes, I think that's one of the things under the constitutional.
Due process, you mean the due process
yeah.
analysis?
I think that's one of the factors that you look at.
So you argue the forum selection clause was not argued by the defendant below, so the defendant can't rely on it now, but the judge put it in the judge's order, right?
Well, actually, it's exactly the opposite. The defendant, the LLC, I believe, is arguing that we didn't argue it properly.
Oh, okay.
And therefore, we can't bring it up. And after, the facts are that after we took over, after the Massachusetts people took over, we amended the partnership agreement and put in a forum selection in Massachusetts. And it was without, and we were allowed to amend without their vote because we had 95% at that time, but it was without their consent.
So they argue that courts consistently hold that ministerial or informational filings into a state don't constitute purposeful availment, and then they cite, for example, Fern versus Immergut. What do you say to that?
I have to judge, which argument was that?
Well, you're making this argument that this mailings into Massachusetts are enough to provide jurisdiction, and they are saying that our court in particular has not agreed with you about that, and they cite a case, Fern versus Immergut, and I'm wondering if you are familiar with that case and if you could tell us why they're wrong about it.
Well, they're wrong about that because in that case they didn't have an underlying contract, which was a result of a significant transaction of business in Massachusetts. That was one where, it was done outside of state. It didn't have anywhere near the connection or the 94% interest.
Okay, your time has expired.
Yes.
And if I see no further questions, which I do not, thank you very much.
Thank you.
Very good argument. We will hear next from Attorney Maglione.
May it please the court. My name is Christine Maglione, and I represent the defendant appellee ELFERS R.R.H. LLC. I will try to refer to the parties as the partnership and LLC, but I apologize in advance if I slip in defendant or plaintiff there. There's a two-prong analysis. It's not just whether or not the long-arm statute is satisfied, but it's also whether or not due process is satisfied before this court can exert personal jurisdiction over a non-resident defendant. And as we've already discussed here, this case concerns the alleged mismanagement of a Florida housing project by a Florida entity who does not own or operate a business here, doesn't have any employees, and admittedly had an isolated solicitation transaction some 50-odd years ago.
Well, I mean, it's not really, I mean, calling it an isolated transaction 50 years ago is not really accurate. For these purposes, it seems to me, you solicited the necessary funds. It wouldn't have happened without the money. The money came exclusively from a Massachusetts investor. That Massachusetts investor took a 95% interest in the project, allowing the project to happen, and then maintained that interest until 2021. And the allegation is that during that lengthy period, your clients breached their fiduciary duty, essentially stealing money from the partnership. That's not an isolated incident. So that's the accurate characterization of the connections to Massachusetts.
Well, in terms of the actions of the LLC into Massachusetts, the isolated incident is one solicitation of an investor. That did not happen continually, and that is a distinction that is important.
So your brother cites Judge Young's case for the District of Massachusetts, and I at least have also looked at the case it relies on from the First Circuit.
Excuse
And
me,
it relies on a First Circuit case. So he cites BCC TC Associates, Inc. This is Judge Young's case. And then that, in turn, cites Hahn versus Vermont Law School, a First Circuit case.
Yep.
I haven't found a state case on this question, but they both say if the contract is formed in Massachusetts, then the fact that the breach takes place, if it's a breach of contract case, and this has a breach of contract claim, the fact that the breach takes place out of state doesn't matter. There's personal jurisdiction over the alleged breacher party to the contract based on the contract having been, I don't know if it says formed here or something about the I can see what it exactly says. If the formation was the result of business conducted in Massachusetts, why doesn't that, if that's the right, I mean, maybe you think the rule is wrong, but if that's the right rule, wouldn't that say, yeah, there's personal jurisdiction? It may not answer due process, but.
beg your pardon, Your Honor. Actually, the BCC-TC case actually supports our argument. While the court in that case found that the long-arm statute did not, that there was no personal jurisdiction under the long-arm statute, it found that there was no personal jurisdiction under the due process clause. So, and I think that's the plaintiff, the partnership's argument is basically associated with the arising out of and relatedness of the long-arm statute, but never is there an argument about whether or not it's unreasonable or there's no purposeful availment under the statute, under the constitutional analysis. And under the BCC-TC case, that is a very similar situation where you have a Georgia law applies, it's a Georgia limited partnership, and the court says it's unreasonable for us to assert under the due process clause jurisdiction. And that's
So they say, and I'm going to look at it right now, but they say there is a rising under for the statute, but there's a due process problem. So I assume you're not conceding a rising under.
I'm not. I think that they're related as well. Here, all the conduct is occurring outside of Massachusetts. I understand I understand my brother's argument that the contract is somewhat breached, but we have other cases here in Massachusetts where there's a purchase and sale of a boat and it's shipped to Massachusetts. There's misrepresentations made in Florida. That's the Roberts case. And we say there's no personal jurisdiction.
All right, let me ask you this.
Yep.
What if the time frame of all of this was compressed? So I have to figure out who did what. The LLC needing investors for the partnership comes to Massachusetts, hires whoever it was, Boston Capital, whatever bank they used to try to find investors. And in fact, they do. They find an investor willing to put in 94% of the capital, hundreds of thousands of dollars. And they sign the contract, and the investor wires the money to the partnership of which the LLC is the, I don't know, general partner, managing, whatever it's called. And the next week, the LLC wires that money to their owner's personal account in the Grand Caymans. And that's the end. Nothing is ever built. It's just total fraud. Would Massachusetts have personal jurisdiction over the LLC?
Well, in your scenario there, the Massachusetts investor still holds an interest, and that's not the facts
Wait
of
a
the
minute.
case here.
I want to, all right. So I want to just take this step by step. So you're saying, yes, if the Massachusetts investor still holds an interest, then yes, that can be brought here.
If the Massachusetts investor continues to own an interest, I think we have a more difficult argument to sustain the unreasonable or, kind of the due process
All right,
analysis.
but we're all on due process here, but let me ask you this. You don't think that the due process clause would let that be brought here?
Well, I think that the law is requiring a causal connection between the wrong and the connection in the forum state.
Yes,
And
but I
here,
would, no, go ahead.
we don't have an allegation that there were misrepresentations or fraudulent solicitation materials in order to get that investor to invest. In that case, there would be
Okay,
a
all right.
causal
Well,
connection.
I don't know when the LLC got this idea of stealing all the money in my hypothetical, but let's say, in fact, that's not what happens. $300,000 of the money goes and the thing is built. But the very third week, the investor looks at the books and they're like, what's this wire transfer to the Grand Caymans of $25,000? And maybe the LLC says, oh, we have a backroom operation for our computers there or something. But it turns out it's just theft by the LLC itself. Don't you think that our courts would have jurisdiction over that?
Well, I think when Massachusetts has an investor that's being harmed, it raises additional concerns under the unreasonable factor test, because that is part of the test. What is Massachusetts' interest in protecting or in adjudicating a dispute that
And
happens?
our interest, or it's actually, I don't know if it's the state's interest, the legislature says maybe it's our interest to make sure that people in Massachusetts aren't ripped off. Our law protects our citizenry and institutions here. And you say, oh, but then the Massachusetts entity is no longer the limited partner. It's sold to someone in Oregon. Presumably, the state still has an interest in deterring the LLC from doing, in my hypothetical, from doing what it did to a Massachusetts investor by conducting business in Massachusetts. The fact that that interest is sold, I don't see why that makes any difference, given that the party is not the limited partner. The party is the partnership itself.
Well,
What's your, I mean, because you do keep saying, like, they don't own it anymore, and I just don't see what that has to do with it. People sell their causes of action to insurance companies in Minnesota, right? The Minnesota insurance company isn't injured at all. But the person has been compensated by the insurance company. They couldn't care less how it comes out. I don't see how selling the entity that has a cause of action, or even selling, in this case, not even doing that, selling the interest in an entity, I don't get why that changes whether we have jurisdiction or not.
Well, I think it changes it because there's a balancing test about what are the sovereign interests here? Who's interpreting?
I
By the
don't
way,
think
Florida law-
Massachusetts, I don't see how Massachusetts loses its interest.
Well, can
Well, all right.
can you answer, I'm hearing the question and breaking it down into some bite-sized pieces. Are you saying What are you saying about the relevance of the sale of the interest from Massachusetts investors to Oregon investors, specifically with regard to the long-arm statute argument and with regard to the due process argument? Can you answer those two questions?
Well, in terms of the interest of Massachusetts in adjudicating a dispute where the entity bringing the suit
Yep.
is not a Massachusetts
This case.
investor,
Yep, right.
then there's no interest, or there's limited interest in Massachusetts adjudicating that dispute where everything happens in Florida and the parties are Florida residents, and there's no interest, and there is a balancing test.
So you're
under the
saying,
due
okay,
process.
so you're saying that's dispositive. I think, what I hear you to be saying, I just want to make sure I'm not mischaracterizing. You're saying because this suit was brought by non-Massachusetts investors, Oregon investors, that is dispositive. Because the malfeasance is in Florida, the people bringing the suit are Oregonians, or then that's dispositive. There's neither long-arm statute jurisdiction nor due process, nor does that satisfy due process. Is that your argument?
That is our argument, but it's not just because of the lack of a Massachusetts entity. It's also because there's a lack of a causal connection between what is the alleged harm and what is the minimum, or the contacts, the historical contacts that happened quite some time ago, that there's not that causation between the two, which is what the case law is kind of demanding.
So the causation between the harm, you're saying the harm, the alleged harm was in Florida. I think that's what your point
Yes.
is. And the causal connection between that and Massachusetts, you're saying is lacking, but I think your brother would say, sorry, your opponent would say that if temporally the harm alleged occurred while Massachusetts investors were involved, and it included sending hiding the malfeasance in financial records that were sent to the Massachusetts investors. That seems like a clear causal connection to me, if that's your...
Well, we have case law in Massachusetts that when you're just sending financial reports into Massachusetts, that's not enough.
Okay. And what's
So-
that? I mean, I know I have it.
I have Telco,
Yep, yep.
and there's also this interesting, it's an unpublished case, but O'Malley versus Bank of Ireland, where there was like kind of the initial establishment of a relationship when that Bank of Ireland had an office in Massachusetts. And then later there's a loan transaction that happens in Ireland, and they say, well, that, because that relationship kind of was established here at some point, that's not going to justify personal jurisdiction in a later transaction that wasn't related to the contacts.
Okay, so your second, sorry, I apologize, go ahead.
So at the time of the alleged malfeasance,
Yep.
was the Massachusetts entity still involved with the partnership, with the whole thing?
Well, based on the complaint alone, I would say, based on his allegations, yes, but I would also point out that there's no affidavit that's supporting those allegations on this claim, on this personal jurisdiction claim, which I think is the plaintiff's obligation. He's relying on a 2015 affidavit to support this claim, and the 2015 affidavit deals with presumably things they didn't know about. That's his whole argument. We didn't discover it till after that. So there's no supporting affidavit to support those allegations that I think is the burden of the plaintiff on a motion to dismiss, to submit that.
We're out of time, so we need to finish up here, but why was there personal jurisdiction over the LLC in the Wrightstone litigation that was brought here in state court?
Well, there was no argument about personal jurisdiction in that case. It's a different case and different counsel, and at that point,
So you're
I'm
not
pretty
conceding.
certain that
You're
the
not
fact
conceding.
that you appear in a case under other counsel that would waive any argument about personal jurisdiction in this case. I would also say that under an alternative ground of forum nonconvenience, this case can be affirmed, as well as that I think the forum selection clause is inapposite because it was.
We have your arguments in your brief about both
Okay.
of those things.
Thank
you
you.
very much. I see no further questions. Your time has expired. Thank you also for a very good argument. The case is submitted. The next matter we will hear is number 25811. This is Constantino versus the Paul Revere Life Insurance Company. And I believe we will be hearing first from attorney, I apologize if I mispronounce this, Gontumas.
Good morning, Your Honors. May it please the Court. My name is Ritza Guntumis, and I represent appellant Dr. Richard Constantino. And sitting with me at counsel table is my local counsel, Stephanie Parker. I'd like to first begin with the arguments in Dr. Constantino's appeal and then move on to a couple of the main issues in appellee Paul Revere's appeal. The first issue that I'd like to discuss with respect to Dr. Constantino's appeal is the issue of total disability. We believe the trial court improperly ruled that Dr. Constantino was not totally disabled from his occupation. Under his disability insurance policy, the policy requires that he be unable to perform the important duties of his occupation.
So I was trying to understand what his occupation was, since he seemed to be doing different things. He was the hospitalist, he saw patients in his office. I think there was a third thing that he was doing.
Good question, Your Honor. So his occupation was his specialty. He was a hospitalist. He was a hospital-based internist.
Okay, so couple things about this. First of all, I've looked at the policy. He could have changed jobs and you'd still cover him, right? I mean, there's a cap based on, I guess, his then current salary, but also the cap protects you. His premiums pay for that capped amount if he becomes disabled. Let's say he had decided he wanted to be a baseball umpire, and he had shut his practice down altogether, and he had gone to some training thing. He did it a lot in high school and college, but now he wants to go back, and now he's a professional baseball umpire. You'd still cover him under this policy, right? This policy, if he kept paying the premiums, he'd be covered, but now he'd be an umpire, and we'd have to figure out what's going on with that.
Are you asking if he became an umpire at the time that he became disabled? Because that's what the law requires.
Before he became disabled. 2 years after getting the policy, he just changes jobs.
Correct. So what the law says is that for purposes of total disability, you have to look at what the insured's occupation was at the time that that person became disabled.
Yes, so he'd be an umpire, and if he became disabled, then he'd be a
Correct.
disabled umpire.
Correct. So that would be the analysis. It would be what his important duties of his occupation were as an umpire under that situation.
Okay, so now the judge relied on the application. I don't know why exactly. I don't know if that was argued below, but the judge said, I've looked at what he said he did in his application for this insurance. And what he said was, I'm a medical doctor, and I engage in the practice of medicine. And then listed a lot of things, including not just being a hospitalist in the hospital, but practicing medicine. So he included hospital work, office work, teaching. All of that was mentioned in the application. And I don't know if this proves anything, and maybe it doesn't prove it's not a jury question, I have no idea. But he then, in the initial correspondence, about how much money he's losing and what he's able to do. There's things where he says, like, I have to cut down on the hospital. I'm hoping that I can make up for it by increasing the office part of my practice. Again, I don't know if it's a jury question or not what his occupation is, but why doesn't all of that point strongly toward, I guess your occupation is being a doctor, and now someone's coming in and saying, no, you're a hospitalist who can't work in the hospital, but you said you were this, and it seems like you thought that was your occupation.
If I may respond to that briefly, Your Honor. So the distinction is not, what the law says is you don't look at what the label of someone's occupation is. It really is a qualitative analysis that involves looking at what the insured's actual duties of their occupation are. So this is a very nuanced issue, but our argument is that the important duties of his occupation comprised of his hospital practice. And the reason I say that is because his office practice and everything else that he discussed in the application and in his correspondence with Paul Revere were incidental duties. And what I mean by that is that they stemmed directly from his hospital practice.
I think they paid 60% of his salary or something, maybe 40. I don't remember what the numbers were exactly, but they paid a substantial part of his income.
So
the office stuff.
Correct, but there is no, first of all, there is no requirement that important duties means that it has to comprise of the substantial amount of your salary. And I do want to point out that the office practice post-disability changed in nature. Not only did it reduce because the number of patients that he saw reduced significantly because they stopped seeing him because he could no longer treat them in a hospital setting, he also could not perform a lot of the same procedures that he was able to perform pre-disability. And most importantly, really the only reason he was able to even sustain an office practice post-disability was because he hired a lot of other people to make up for that and do the work that he could no longer do.
But can I jump in? Wait,
Sure.
There's two analytical frameworks here, and you've jumped into the second one. There's two, under the policy, can be simplified dramatically. He has an obligation to report his, the loss, and it can either be a residual disability or a total disability. And they're defined differently. One is, you know the definitions. And then there's a secondary requirement that if he's claiming total disability, he has to actually meet the definition of total disability. All of this is about that second thing. But with regard to the first requirement, he has to file a requirement. He has to file a report of a total of proof of loss. He has to file a proof of loss. Correct me, when did he claim in writing that he had a total loss before February of 2017? Did he ever, where can you point in the record that he alleged in writing, I have a total loss?
So he had explained, There's two distinctions, Your Honor. Are you referring to the total disability analysis based on his inability to perform his occupation or presumptive disability?
Yes, that one,
Yes.
not the presumptive.
Okay. So for total disability, he had explained to Paul Revere numerous times that he was not able to perform the important duties of his occupation. There's a specific letter. I believe it's in the record as AO 193, 199.
193 to 199, is that what you're saying?
Correct.
Okay, but so his doctor, Maxwell, who did the back surgeries,
Yes.
is saying repeatedly he can walk some, he can walk short distances in this same time period. I mean, I understand, to back up and clarify my question, which is a little bit unfair, there were, between 2013 and the end of 2016, where there were the two operations, there were two periods, distinct periods where he was totally disabled because he was recovering from back surgery. I understand those were total disability periods, and he was paid total disability rates. Put those to the side. The rest of that period, 2013 to the end of 2016, the question is whether he's ever, my question is whether he ever, in writing, claimed proof of loss for total disability.
Your Honor, I believe that he did. He had specifically indicated in multiple attending, his doctors had indicated in attending physician statements that he had completely given up his hospital practice after his first surgery.
And that's not by the definition. That, I guess that gets us into the second problem, the second requirement of the policy, that he prove that he has a total disability. And he clearly, and this is in your brief at, and this is all about how much he is able to do, is a hospitalist. He's not, we can all agree, for long chunks, maybe the whole time after the first operation, he couldn't go to the hospital and do rounds. Does that make him a totally disabled? You characterize the rest of his work as inconsequential, trivial, incidental, and incidental duties like administrative office work. Now, frankly, when I dug deep into the record to figure out what is he actually doing from 2013 to 2016, I became very uncomfortable with your characterization as an officer of the court of what he was actually doing. Because in fact, I learned that as late as 2021, he's saying he has thousands of patients on his roster. But broadly, he's seeing patients and charging for it, charging insurance companies and others for seeing those patients all along from 2013 to 2016. And I learned also that his revenue, more than half of his original revenue, 65% more or less, is those office visits. How is it plausible to say that that work is inconsequential, trivial, incidental, or administrative office work? How are we in the same universe?
So it's because the only reason he was really able to even maintain an office practice post-disability was because he had hired other people to actually come in and carry out those duties on
So
his...
he wasn't seeing patients? That's what you're saying?
No, I'm not saying that. He
Wasn't charging for seeing those patients?
He was seeing patients, but there's no dispute in the record that his office practice diminished substantially.
I agree with that. That's what everybody agrees with. The question is whether he was totally disabled.
Right.
And it sounds like if he's seeing, to my mind, he's lost an important piece of his employment, seeing people in a hospital, but he is still seeing people on a regular basis, apparently lots of people, and generating income throughout that period. That's not totally disabled under these definitions, is it?
We would disagree with that, Your Honor, and the reason we would disagree with that is for the reasons that we had just argued previously, which is, again, his office practice is directly tied to his hospital practice. He would see patients that were released from the hospital in follow-up in his office setting. And the nature of his office practice really changed post-disability.
How?
He could not do, so in addition to losing the physical capabilities because of his feet being totally paralyzed, he was not able to first examine do a history of his patients in the office, walk to the exam room, examine them then. In addition, because of the severe spinal stenosis, he lost feeling in his hands and his arms. So he couldn't do a lot of the same procedures that he was doing before. And again, I really think it's important to stress that he ended up hiring physician's assistants, nurse practitioners.
Can I ask you a couple quick questions?
Sure.
Because time is short. Is the question of whether his profession is hospitalist or doctor, is that a fact or a legal question?
It's a fact.
Did you argue below that, as a matter of fact, he was a hospitalist? Did you argue that this is summary judgment, right?
Correct.
That summary judgment couldn't be granted because it was a material fact that had to be resolved by a jury?
Yes. Yes, we argued that whether or not he was able to perform the important duties of his occupation presented a issue of fact that needs to be decided by the jury, and it was improper to be decided on summary judgment,
Okay,
correct?
and this letter at 193, 199, I can't quite tell what volume I'm looking at, it's from 2017, is that right?
It is, Your Honor, and I might have...
Okay, so the answer to the question, did he say, I'm totally disabled, to the insurance company, he didn't say that until 2017.
I don't necessarily think that's correct. I know that there were, in addition to there being attending physician statements from his doctors, I know that there were claimant statements that he had provided that specifically talked about the nature of his duties. There was one from 2015. It was March of 2015. Let me just quickly check the case citation. believe it is Exhibit 17, so AO103 to AO106. But the reason I pointed you to that letter is because that letter specifically, it was an opportunity for Dr. Constantino to really explain
Well, that's fine, but the point of Judge Wood's question, I think, was about the proof of claim and when it came in. And of course, there's a dispute about what the period might mean, and we get that. But it's not that you're arguing that proof of claim, whatever that is, was submitted in 2013. You're just saying that it doesn't clearly say that the period is monthly, which it certainly doesn't do, right?
It sounds like you're dealing with the contractual limitations provision now?
I think within
Oh,
the
no.
policy
Oh, yeah.
required written proof of loss to be sent to Paul Revere within, quote, within 90 days after the end of a period for which you are claiming benefits, close quote. And periodic payments would then be made every 30 days. That's section 7.6 of the policy. I think that's what Justice Rubin is getting at, that, yeah.
I thought that's what you were getting at when you asked
We're
for the proof.
both getting at it.
Okay.
Yeah,
Because I
proof
wasn't.
of, right, sorry. Proof of loss is required. The judge articulates how she was reading this, or he, I can't remember, was how the judge in the summary judgment decision articulates how he or she was reading that. And that made sense to me. And that you have to notify us within 30 days of every 30-day period where you are claiming total loss. By your definition, I am totally disabled. Under the definition of total disability at RA 220 in the policy, total disability means you are unable to perform the important duties of your regular occupation, as opposed to residual disability, which is you are unable to perform one or more of the important duties of your regular occupation. The judge gloss on that is, okay, so total disability means you can't do anything. And clearly, your doctor can do lots of things even after he stops going to the hospital. That's the problem for you. So why is this a total disability if he's still got a practice where he's seeing patients and billing for it?
So our position, again, is that it's a total disability because the important duties of his occupation really were the hospital-based duties that he was performing.
Right.
That was the essence of his occupation. So that's our argument. That's why we think that he's totally disabled, because those were and comprised of his important duties.
The defendant argues that nowhere in the original or amended complaint did your client make a demand for interest payments for a delay in the payment of benefits. I just wondered what you'd say to that.
I believe we had addressed this in the brief, and I believe what the Superior Court had said about that is that we didn't need to specifically allege every single item of damages. The first amended complaint, as well as the Chapter 93A demand letter, specifically put the defendant on notice of the types of damages that we would be requesting.
Your time has expired. I see no further questions. Thank you for a very good argument.
Thank you, Your Honors.
We will hear next from Attorney Collins.
Members of the panel, and may it please the court, my name is Chris Collins, and I represent the appellee and cross-appellant, the Paul Revere Life Insurance Company. Justice Wood, you have the policy down to a T. You understand it exactly how it's administered. What the company does when they have a total disability claim, trying to evaluate is someone unable to perform the important duties of their occupation. They look at the time of claim, what they were doing, and they try to match up what they're continuing to do. And as you said, he keeps CPT codes like every physician in the United States does that tracks every single procedure they do as a physician. And when they did that, they found that 65% of his CPT codes were things that he did in his office. And to his amazing credit, he still works today.
Things he did in his office, not administrative things.
Seeing patients,
Right.
Diagnosing conditions.
Don't you think it's a question of fact whether he's a hospitalist or a doctor?
A hospitalist is a title. You can call yourself anything.
You can. Don't you think it's a question of fact?
Yes, it is a question of
So
fact.
shouldn't it go to the jury?
Well, no, the facts are clear. And on summary judgment, the court understood exactly. There was no dispute
Well,
about
your-
what he did before
your,
and after.
Your opposing counsel is saying these are two separate jobs. He's allowed to do this other one in the office. The one in the hospital, he was totally disabled from, aside from presumption, which we'll get to, I'm sure. Why isn't that a question of fact for the jury? Are these two separate jobs, or this is one thing?
They're not two separate
I
jobs.
understand.
They're
Why isn't it a question of fact?
There were no facts in dispute on that issue. There was nothing for a jury to break down. He gave himself a title of hospitalist kind of late in the game. He's
Lots
an
of
internal
things,
medicine-
lots of things he did were kind of late in the game. I agree with that.
He's an internal medical physician. I really want to spend my time on this. The Superior Court erred when it applied Chapter 176D and 93A to this dispute.
You're talking about your cross appeal now.
I am talking about.
Yeah,
my
we'll get to
cross-appeal.
that, I'm sure, but I want to talk about their appeal first. I want to talk about not just his title. I want to talk about written proof of loss and the basis for not going back to 2013. I assume this has been changed in subsequent policies that have been written, since there seems to be many cases, several cases at least, about this very sentence. Written proof of loss must be sent to us within 90 days after the end of a period for which you are claiming benefits. A period for which you're claiming benefits.
Yes.
You say without citation, oh, down below it says we're going to pay benefits periodically, so those are the periods. It doesn't say those are the periods at all. It just says when you're going to pay. That doesn't mean you're necessarily even paying after a period of any significance. You're just going to pay monthly. They're payable periodically at the end of 30 days, and so on. I searched the contract, though. The word period as a description of anything is only used in two ways that I can see. One is period of disability. Many times in this contract there's a reference to a period of disability. There's also the maximum benefit period, but I think context suggests that that can't be what this section 7.4 is talking about. If I were the person reading this, why wouldn't I think the period for which I'm claiming benefits is my period of disability? I guess within 90 days after that, I have to get something called written proof of loss in. I'm not really sure what that is, but why isn't that actually the most natural reading of this? I mean, I know you'd like it to be a month, but it doesn't say that anywhere.
It's a monthly indemnity policy.
Where does it say that
on
the
the
periods
face-
are a month?
Well, the rate of monthly indemnity is on the schedule page.
Hold on.
So the very, it's a couple of pages in. It's it's a page A70, volume 1 of the appendix.
Well, I'm actually looking in the,
And the schedule page says rate of monthly indemnity. This is a monthly indemnity policy. You have to prove you're eligible for benefits every month. And it all ties together. It's a monthly indemnity policy. And that provision, by the way.
why isn't it at least ambiguous? You don't call anything the monthly period anywhere. You could have put in every month for which, or you could have put in definitions. Period refers to each month of disability. You didn't do any of that.
That provision comes right out of New York statute. And it comes out of almost the statutes in every state
And the
in country.
statute says that it's monthly?
No, the statute has the language of proof of loss. And what the statute says is you can file a policy in this state and have it approved if you don't have language that's less favorable than what you read below. And the language you read below is almost word for word is what is in this
Well,
policy.
you drafted this in Massachusetts, which gets us to your cross appeal.
No, we didn't.
You didn't.
No, well, the
You're
policy.
in Worcester, so far as I know.
The policy might be physically.
Still in Massachusetts, right?
Policy might be physically drafted in Massachusetts, but every single state in the United States approves policy language. And New York is known as the most rigorous of insurance departments in the United States. You have to have their policy reviewers
Okay,
approve
I'm not
every word of
saying
the
it's
policy.
not approvable. I'm saying, why doesn't period at least arguably mean period of disability?
Because I think when you read this policy in whole, it's unmistakable that it's a monthly indemnity policy. And if you look at the interactions between Paul Revere and Dr. Constantino throughout, he was constantly, working back and forth with the person that was handling his claim under this residual disability benefit to prove his monthly eligibility for residual disability benefits. He had to prove on a monthly basis, what were you earning? What were your losses? And then the company, they would together try to work to figure out how much of the benefit are you eligible for.
And where does it say that, that he has to prove it month by month?
Well, I think the proof of loss provision, and you actually read the time of payment of claims. It says we're going to pay claims every 30 days.
You can pay claims every week if you want,
No, but it
or you can
says-
pay them quarterly. That's
says-
not the question is what's the period that he has to, within 90 days, give proof of loss? And
This
I'm
is
having a hard time with it because, as I say, the only period mentioned anywhere in here is period of disability. And you can see how a disabled person might think, I'm still in my period of disability. This goes on and on. I keep hoping I'll get better, but I'm not.
Under the time of payment of claims, under section 7.6, this is on. in the
No, I
record.
see it, of course, yeah.
If you read section B, we will pay at the end of each 30 days any benefits due that are payable periodically, subject to continuing proof of loss. You have to submit proof of loss every 30 days. That's what it says in the policy. Subject to continuing proof of loss.
That's an argument I like,
Thank you.
because it says proof of loss.
Thank you. So, back to our appeal and Chapter 176D and Chapter 93A. This is a matter of New York insurance law. Dr. Constantino has been a resident of New York for his entire life. Before Paul Revere could have sold any insurance in the state of New York, it had to be a licensed, admitted insurer in that state. Before Paul Revere could issue any policy, it had to submit for approval to the New York Insurance Department every word of every policy it has ever written. For every dime of premium it collects from a New York resident, it has to pay New York premium taxes. Before it can underwrite a policy, it has to underwrite those policies under the underwriting guidelines of the state of New York. And when it comes time for claim, it has to handle that claim under the Unfair Claim Practices Act of New York, not Massachusetts. When Dr. Constantino's lawyer first wrote to the company in March of 2019, he wrote a 13-page letter. In that 13-page letter, he cited nothing but New York law.
Well, he doesn't get to decide which law applies.
Certainly doesn't, but it's an indication of what everybody understood was the law that applied to this. In response to that letter, Paul Revere did reconsider its decision on the presumptive disability claim, and it paid it. A year later, he wrote to the company in May of 2020, and that was his Chapter 93A demand letter. It said nothing about, we're disgruntled with the payment that you made to us on the period of benefits where you reinstated benefits back to 2017 because it lacked interest. That letter was almost identical to the, except for the length of it. Now we have a 3-page Chapter 93A demand letter, which says the same thing that the March of 2019 letter said, which is, pay me my benefits back to 2013. The company had already responded to that, and that's why I'm saying in the brief, he has gamified Chapter 93A. He got the company to give it its full measure of settlement in response to you're violating New York law. And then when the company gave up its full measure of settlement, he now writes a Chapter 93A demand letter. The company has exhausted its settlement. It never got the
After filing the complaint, is that right?
Excuse me?
After filing the
2 days after he
Yeah,
filed his
right,
complaint.
sorry, yeah.
And didn't mention that I sued
Did the
him 2 days
complaint
earlier.
have 93A in it, or was that an amendment
Not the
after the
original
demand?
complaint.
Yeah, okay.
He amended it after he sent the 93A demand letter.
So, but the question of which state's law applies. You're a Massachusetts company. Your insured says you did something wrong, outrageous, unfair, and deceptive. And actually, the judge found that, but okay, in the 93A portion. Do you think Massachusetts doesn't have an interest in regulating companies doing business here?
They absolutely do. And what they expect is this, especially a company like Paul Revere that's licensed in all 50 states. You have to follow the laws of the states where you're doing business. That's what Massachusetts expects.
Well, yes, but of course Texas doesn't care about unfair and deceptive acts and practices.
Sure
but our
does.
legislature does. I know. It's a joke. Our legislature, though, does. Or even for that matter, New York has this great law, but the Attorney General, who's a very busy person, has to bring those suits. Luckily, we have this highly protective little FTC Act where private individuals can sue to enforce it, and we're going to really make sure I just don't understand how Massachusetts can have no interest in, in the business that you've done with your client.
Massachusetts
your
has an
insured.
interest. The Massachusetts Insurance Department expects this of every domiciliary insurance company in the state, of which there are not many left now, by the way. They expect that you follow the laws of all the states where you're licensed to do business. And if you don't, you might catch fire from the Massachusetts Insurance Department. But the New York Insurance Department can come into Paul Revere anytime it wants and do a market conduct exam and take away the company's license if it's acting untoward toward its policyholders in that state. And so can any of the other 50 states. Paul Revere was regulated by 50 different states. Having a license to sell insurance in Massachusetts does nothing for you to sell insurance in New York.
Right, but so,
This
right.
contract doesn't say it's governed by New York, like everything's New York law, right?
Well, it doesn't say that, but it mentions New York specifically in several different places because this is a New York approved policy. This policy, word for word, you would not find it in any other state, only New York. It's a New York approved policy. They approve every word that's in here. And as I said, they are the most rigorous insurance department in the United States. This policy wasn't available in any other state. You had to be a New York resident. Every case that
Wait, before you do,
Yeah.
the analytical framework we're supposed to apply here is established by this court. It's a question of precedent, right? It's the conflict of laws analysis which we find in the restatement of conflicts of laws, second of conflict of it's this esoteric thing. We don't have a choice. We're applying precedent, right?
Yes.
And the precedent tells us that when you're dealing with a disability policy, that matters. You go to section 192 of the restatement second, right? We're supposed to follow this flow chart, right? This is your argument, right?
Yes.
And that under 190, so it doesn't matter how important Massachusetts thinks 93, or does it? I don't know. But the 93A claim or the reference to New York law in the policy, what we have, the precedent tells us we follow the restatement second's analysis of this question, right?
Yes. And I think the restatement understands, especially when it comes to insurance, how it's been regulated historically. McCarran and Ferguson
I have
gave
to
the
say,
right to the states.
I have to say, I don't see how Section 192 applies. It is about the validity of contracts and the rights created thereby. And 93A is not created by the contract. 93A applies to everyone doing business in Massachusetts, whether they're an insurer or not. It seems to me that we have to look at Section 6 and try to figure out what that.
The ultimate position is it doesn't matter whether you look at a conflict of laws analysis under contract or tort. It all leads to New York. Look at the cases, Riker versus Berkshire Life. Riker was a Maryland insured. This is a First Circuit case. The First Circuit said Maryland laws apply. Aaronstein versus Mass Mutual. Aaronstein was a New York resident. Mass Mutual is in Springfield, Massachusetts. The court in that case said New York law applies.
Which court?
These are federal district court cases. There are no state law cases on this issue. And then finally, Meir versus Sun Life. Sun Life is in Wellesley. Meir was in Arizona. They said Arizona law applies to the decisions that were made in the headquarters of these various companies in Wellesley, in Springfield, in Pittsfield. Those decisions are not regulated by Chapter 176D or 93A if you're a foreign resident. And the other interesting thing here is there's a case in New York, Oberlander versus Monarch Life. Monarch Life is in Springfield. When it was open, was in Springfield, Massachusetts. They denied a claim to Oberlander in New York. He brought a claim under Chapter 170-60 and 93A. It went up to the appellate division in New York, and they said, they agreed that you analyze this as a tort, and they said the tort happened here in New York, not in Massachusetts, where the communication was received by the claimant. Just because the decision was made in a Springfield, Massachusetts claim office. And I wanted, the most important thing I wanted to say before I leave, I have to say this. If this becomes precedent, that the physical location of a claim decision by a domiciliary company is where the law applies with respect to claim handling, most people in Massachusetts will not be able to file a Chapter 176 or 93A claim.
We saw that argument in your brief. Your time has expired. Thank you for a very good argument.
Thank you.
And the case is submitted. The next matter we will hear is number 23675. This is State Police Concord versus EL-BAYEH. And we will hear first from Mr. EL-BAYEH. Now, I know you're representing yourself and are not an attorney, and so you may find this, although I don't know for sure, you may find this difficult or intimidating, and we're going to try to make it as easy for you to be comfortable making your arguments as we can.
I've done this twice before, so.
Say that again?
I've done this twice before, so.
You've argued before the appeals court twice before.
Hey, yourself, Your Honor. That's right. 5 years
Yes,
ago.
I remember that case. All right, so,
Yes.
of course, yes, I remember that case. So, having said that, you're still not a lawyer, so, you know, we'll try to make this okay. So with that, we'll hear from you.
Good morning, Your Honors, and may it please the Court. I'm MIKHAEL, defendant appellant pro se. I intend to address each of the 3 claims of error on appeal this morning, beginning with the denial of the motions to dismiss, followed by the denial of the discovery motion, and finally the admission of LIDAR-based evidence over multiple objections. Addressing first the denial of the written pretrial motion to dismiss, which is reviewed de novo, there are 2 constitutional bases for the claim of error. Under Washington and Rodriguez, suspected CMVI violators have a right to be free from the equivalent of an arrest, the issuance of a citation, absent probable cause. And under Article 12, and supported by Murphy v. Superintendent, CMVI defendants have a right to have the alleged offense fully and plainly, substantially and formally described to them before they are held to answer.
Right, so I want to jump in here to sort of simplify it and make it concrete. We're talking about your gripe, your central gripe is that I think the court file didn't have a copy of the citation in it, right?
Yes.
Right. Now, that's the gist of it. Because that's the fatal flaw, I think. This is really simple.
Correct.
There was no citation here. If it were a criminal case, it would be a complaint. But there's no piece of paper that we've all seen it, a uniform traffic citation. That thing is not in the file, right? That's your gripe, right?
Essentially, yes, Your Honor.
And that's a due process violation, you're saying?
Exactly, Your Honor.
Right, okay. So, and the reason that that's unfair, I think you're saying, is well, you tell me, but I think what I come up with is lack of notice. Is there some other thing that, in plain English, is a problem with a lack of citation?
You're right, it's a due process claim, so.
But due process is a lawyer word. What's the actual problem? I think the actual problem is I didn't get notice of what's the due process violation, we would say? I would say notice. I wasn't given adequate notice of the problem.
Correct, Your Honor. I think, well, it was their burden to show that it was given proper notice, and I think that their burden required that the citation come to the court file and the judge review it for probable cause. So without probable cause, we shouldn't have gotten to the liability hearing. I think that's like the gate, like they have to.
Okay, so.
You were the person who started the process by appealing the ticket, correct?
Well, I mean, the process started from the ticket is issued and then sent to the RMV.
Right, but you then got into court, and you got into court because you filed something, correct? Or you sent something in?
I mean, that's not on the record, but I mean, you can just ask the RMV for the hearing, then they send something to the court presumably, and they, tell you have a hearing.
Well, what is in the record is that the officer, the trooper, testified that he handed you a physical citation. I'm a little confused, and you can help me out here. He also said, I filed an I executed an e-citation, but he gave you a physical, on the road, he gave you a physical copy of the citation, right?
Well, don't,
Oh, okay.
yeah. He says he did, right?
He says he did, right, sorry, I don't want it, right. Thank you, Justice Rubin. So the judge is able to infer, I think, from the record, here's what I get on notice. There's no citation in the physical court file, but the trooper, in response to a question from the judge, says, yes, I gave him a copy of the citation physically at that time.
I think that gets more into my second motion to dismiss argument, which is the statutory basis under the no-fix. And so I think under that, you have the right to be served at the time and place, and you have a right to prompt and definite notice. I think the Pappas case stands for that proposition. And I think that, citation is a very specific thing. It's defined by the court rule. It has to have a certain form and parts and all that. And all he said was, I served him something at the scene.
All he said? Well, to me, the question is, I'm going to reframe that. To me, is the judge, having gotten that testimony under oath from the trooper, able to reasonably find that, by the appropriate standard, that you were served with a uniform citation and given notice as a result of that in satisfaction of the no-fix statute?
I don't think so, because it's the substance of the notice, not just the fact of notice. That's essentially my argument.
What's the substance that was denied by the inference? Well, let me back up. It seems to me the judge can infer that you were given, the judge has seen all of these uniform citations are not complicated, they're forms, and the judge has seen lots of them, that you got all the information in the citation. Why is that not a reasonable inference?
Because what was in the citation? We don't know. We have no idea what was on that form if it was served at the scene. I mean, it never came in. She never looked at it.
So your position is that in all these cases, the actual citation has to come in, no other evidence is adequate?
Well, I mean, maybe you could, testify in detail to like every field in the citation and, everything that's actually on the form, but he didn't do that here. And I think that, and I do cite, there's two things that I cite, and one is the statute, section 221, section 62C, which contemplates that, for the magistrate to hear it in the first instance, the citation is supposed to be received. It references citation. It doesn't say testimony. It says it's very specific citation. And the second thing that I raised in my brief is...
What statute? Tell me the citation for that statute.
Chapter 221, section 62C, sub E. And so that's kind of at the front end. And then if you look at the back end, under the uniform rule, subsection D2, the appeal is informal to the appellate division, but the one thing that you do have to have on appeal is a copy of the citation front and back. And so I think that's kind of another support for the fact that the form
Wait
itself
just a minute.
has to come in.
I'm just looking at these statutes.
Sure.
So the first one, 62C, says under which letter?
Sub small e.
Receive citations and hold hearings. Okay, and then what's the other statute?
So it's the court rule, the uniform rule, trial court rule 7, uniform rule, sub small D2. And that contemplates that, when the appeal goes to the appellate division, they need a copy of the citation. That's like the very one specific thing about those appeals. So I think that's...
Wait, the trial court uniform rule for what?
The uniform rule for hearings on civil motor vehicle infractions, Rule 7.
Okay, hold on.
7.
The rules on civil motor vehicle infractions, and where exactly in this?
Small d, 2.
Small d.
While he's looking at that, do you have a case which establishes that the lack of a physical copy of the citation in the document, in the case file, warrants dismissal?
No, I don't.
Okay.
So I want to turn to the video that someone provided us. So I had two questions about the video. The first is, in both videos, like a large portion of the image is sort of this gray and black So was that in the original exhibits that the judge saw below, or is this some malfunction that we're getting?
Who provided you the, I didn't, that wasn't.
This is a screenshot of one of the videos, and it shows these geometric features in gray and black.
I wasn't served that. I don't even know how that came into the record. I'm
Okay.
confused about what that is.
All right,
I'm a
well,
little confused too.
my,
Were there any videos in the record?
In the record, yes. In the record appendix, no, because
So
I
you-
wasn't raising any claim.
okay,
based-
So you didn't submit them as part of the record appendix?
No.
Okay.
I'm not sure where that came from.
okay, because the second question was, the first person could have been you, but I didn't know what you looked like, so, but the second video is a red truck, which is definitely not you.
That was a single justice motion I raised for the Montgomery motion. It's not raised on appeal. That's something that was
Okay.
raised and not pressed here.
So
That's a
what-
whole separate thing.
On the discovery motion, you state in your brief that the trooper testified that he relied on the True Speed S guidelines and manual, but it seemed like from the transcript he was actually referencing his training manual. I mean, that's what he says at RA 332. And the judge gave you an opportunity to look at that manual. So how do we know there's some different manual that you did not receive?
I guess my argument is that, I'd asked for the manual in advance via the discovery motion so that I could have it for, cross-examination for understanding whether the test he was going to claim that he performed was done correctly. And so, he did bring his training manual, and I think there's a little bit of confusion in the hearing whether,
There was, but ultimately, the judge said, you're talking about your training manual, and he said yes, and then there's a second question about the training manual. So I'm trying to understand what basis you have to say that there was some different manual, that there was some operator manual.
In the record, he refers to the True Speed S guidelines, I believe, during his testimony. And I'd objected to that coming in, to any reference to that coming in, because I wanted to see that ahead of the hearing, and I was denied the opportunity to have that.
So if you already, I think you contend you already had the trooper's home address, correct?
Yes, and his answer to my separate civil lawsuit. he had-
Right, so why did you need to have that disclosed to you in discovery in this case?
Oh, I wasn't asking for the address. I wanted to see the testing site.
Are
Which
there
they said was his home address.
Apparently, yeah.
Yeah, but you can't just go walk into his property. You would
No,
need a court order to do
They
that.
could just not testify to it if they don't want, I mean, if they testify to it.
And
they
let
can
me-
open
let
the
me
door.
ask- well, go ahead.
You did have the opportunity to see it, if not necessarily enter his property, but see his property, correct?
I don't think so. I mean, I think they mentioned it was his backyard. I mean, I'm not going to show up to his backyard without a court order. I mean, it's.
You're trying to, I think the gist of this particular piece is you're just trying to figure out, there's a distance here. This
Right.
test, this calibration test
Right.
involves a distance to a fixed point, and you want to see the distance. You didn't have any idea that that was his home address. You're just trying to,
No, of
right.
course-
So your
yeah,
point
no.
was that's what you want, and now we've created a problem because.
Exactly.
Right, okay, I got it. Back up to, I was confused, I'm glad Justice Henry asked this question. I was operating under the assumption that you filed a motion for discovery of the user manual for the LiDAR.
Correct.
Did you do that? Is that in the record?
Oh, yes, that's in the record.
And
Yes.
then the judge denied that request for the user manual?
Correct.
And that is, and among other things, that user manual, we're told, explains the calibration tests.
Right, presumably the testing procedure, how to properly
Right.
operate it, the operating limitations. I mean, the Vasher case, I think, is directly on point that I cite in my brief, where that was denied to a different CMBI defendant, and that was per se reversible error. Like, that was.
Yeah, okay, but so, yeah, I've got that too. All right.
So I think the Commonwealth or the state police might argue, or the implication of their briefing seems to be, this is supposed to be an informal process. And frankly, if every person who got a ticket in Massachusetts insisted on inspecting the radar gun or the LiDAR gun and see the testing citation, that basically government would grind to a halt, and we just can't do that. So why should we allow that? I mean, the burden is, maybe it's not much for your one case, but if that becomes the precedent, then you will basically bring law enforcement, at least on speeding, to a halt. Or we'll stop using accurate technology, and we'll go back to the days where the police officer says he was going 75.
I mean, I think at a minimum, the manual has support in the Vasher case. I mean, that's not a big burden. I mean, you file a request, they email you a copy of the manual.
Well, they could put the manual online.
No, they
They could put it
can't,
online,
because
yeah.
it's got trade secret,
You could do
there's
that, yeah,
protection,
I mean,
but,
they could put it online.
right,
The
yeah, but that doesn't work.
operating-
You wanted to inspect the device, you wanted to inspect where it was calibrated.
I mean, you have a discovery right. I mean, efficiency is one thing, but justice is another. And so I would say that,
Well, do you, if everybody asked for that, what do you think the consequence would be? If we granted that for every person who wanted to challenge their speeding
guess they'd
ticket?
have
I
to-
mean, like, literally, the burden on them, the burden on the courts,
they
because,
have to come up with an efficient process. Maybe they can put it online. I mean, if they just point to a website where it's all there and ready to go, I mean, they can do that.
well, what if there's proprietary technology in there and they can't put it online?
Yeah. I mean, I just think that at least the manual, I think, is not a big ask.
What about the other stuff? You wanted to actually inspect the device, which means it can't be in use in law enforcement while you're doing that.
Yeah, I mean, maybe that's a tougher road to hoe.
What,
Okay.
you got, I want to talk, you got, in a public information request, the calibration report that had been performed that year. It's an annual calibration by an external entity. I guess that means a third-party company. And you actually got that calibration report before the hearing here on your own through a public records request, right? And so is that in the record?
No.
Okay. I mean, the judge, you and the judge had an exchange about it. That's how I know about it. So to that extent, it's in the record. And so is it, I don't know, I don't want you to go outside the record, but I didn't see this mentioned. Well, I don't know how to get at this, but I'm curious what was in the calibration report that you got. If it's not in the record, I guess we can't talk about it.
I don't think it does anything for the state police if it's not on the record. I mean, I think that's the bottom line.
But you did say that you get the serial number for the device on the report. That's in the
Yeah.
record,
Piece of
right?
paper,
And
serial
so,
number, right, yeah.
among other things, you said, if at the very least, could they give me the serial number? What you said, I think, and correct me if I'm wrong, is I want to confirm, among other things, that the serial number of the LiDAR that this trooper used is the same as the calibration report to make sure that this gun that was used to check my speed was the one that I have a calibration for report.
Correct. Yeah.
Right.
That was in support of my discovery motion. I mean,
Right.
that would have been exculpatory if it
That-
didn't
that-
match or
Yeah.
didn't exist. I mean,
Right, but it had been, the same gun had been calibrated by this external entity. That's what you're getting at, right?
I mean, there's a
There's-
claim, I suppose, of that. Yeah.
But that's one of the things you were asking for, right?
Well, I already had
A certificate, I thought.
The certificate I wasn't asked for the discovery motion. I mean, I already.
No, you're asking for the serial number of the radar gun.
Yeah.
Right,
To see it on it.
right.
Yeah. Right.
So, do you agree in theory that LiDAR is a reliable technology to accurately measure a vehicle's speed?
I'm not conceding that, no.
Okay. Do you agree that speed can be determined by distance and time
Yes.
using math? Okay.
Is there a picture in the record of the testing area, the 100-yard, 100-foot, whatever it was, at the officers?
No, just testimony, just his testimony.
Okay. I see no further questions. Thank you very much. You've done a fine job.
Thank you.
And we will hear next from Attorney Kelly.
Good morning, Your Honors. Siobhan Kelly on behalf of the Department of State Police. This is my first time in the appeals court. So I'm hoping that the court will go easy on me as well. A few things that I just would like to address right out the gate. Justice Wood's question about the concept of an e-citation, which I think may go to the question of whether or not a physical copy of the citation was in the court's record. Right now, across the Commonwealth, every single marked state trooper travels with a computer in their cruiser as well as a printer that allows them to print out citations to serve in hand to members of the traveling public. But in addition to that, e-citations are entered into a statewide database, and that information is automatically transmitted to the Merit Rating Board with the RMV, where you can request to appeal a citation, as well as to the trial court system.
Okay, but that's not all in our record, is it? Or is there some place you can point us to where we could take judicial notice of that?
I certainly could point the court to the acronym I know is MACCS, which is the name of the system that was created in order for the transmission of that information. I could certainly file something supplementally with the court.
What difference does all of that make? I'm not
I
sure.
think it goes to the heart of this question that Mr. El-BAYEH has raised about a motion to dismiss for lack of probable cause because the citation was not in the record, as well as this question of no fix. Beginning with the alleged violation of the no fix statute, the record is clear. Trooper Sierra did testify to serving the citation in hand. It's in the record appendix at page 335.
I thought that was a good argument, and then I've now looked at this rule of the trial court, and you don't address that in your brief. It says, upon receipt of a claim of appeal, the clerk shall promptly transmit a copy of it together with copies of all papers in the case then on file, including the citation, front and back, to the appropriate appellate division. That wasn't done, apparently.
Apparently. What I would say.
Well, okay, it's not in the record, so far as we know, the appellate division never had this. And the rule says they're supposed to have it, presumably because of all the reasons we want a real, we want to know if there was a citation, and there's also the no
Sure.
fix, what date was, all of that.
Yes.
Why shouldn't it be dismissed on the ground, the case be dismissed on the ground that this is being transmitted presumably so that the court can see if there's probable cause? It wasn't transmitted. How do they know? Dismiss it.
Well, Your Honor, candidly, I cannot speak necessarily to what happens on the back end with the trial court in terms of the creation of the file. What I would say, or what I would offer to the court, is that that uniform rule being cited by Mr. El-BAYEH, I believe predates the creation of e-citations.
Has it been amended or repealed?
I don't believe so.
So it's still the rule.
It is still the rule.
I mean, the Commonwealth is in every one of these cases, or some state entity. They could have said to I don't know when you adopted e-citations, I'm guessing not that recently, and you could have gone into the court and said, like, look, it's not going to be paper anymore. It's going to be a screenshot, or it's going to be whatever, and they could have amended the rule to say that.
I think that
might be a good
is
idea.
certainly something that we can raise with the Office of the Trial Courts. However, I do think that there was sufficient testimony that this citation was served in hand by Trooper Sierra. Mr. El-BAYEH had ample opportunity to cross-examine.
Well, I thought that was a good argument, but now I'm just saying the rules say they have to have the citation, front and back.
Can I ask, I'm still not, we are now in a paperless world, sort of, kind of. I'm not. But if, aside from Justice Rubin's serious question about what the statute actually requires, I want to back up, and maybe or maybe not this, maybe this doesn't comply with that, I don't know. But you started to talk about the e-citation process, and I don't want you to go outside the record, but it sounded like you were saying this e-citation, he hits send from his terminal in his squad, whatever his car is called. Cruiser, right. And it goes to two places, physical places, the merit rating board, and it goes to the trial courts. So the trial court, what I'm taking is that the trial court here, and her testimony, I read it very carefully, she didn't ever say what she had. She said, I have this. And I was like, what is that? Well, I don't know what you're talking about. And it's not in the record, and I think we're all saying, why is it not in the record for us? But what I'm wondering is if she had access through the trial court system to the physical copy, front and back, of the e-citation, of the citation. Is that what was transmitted? In other words, could she or her clerk have hit print and gotten a physical copy of it?
Your Honor, that's my understanding of the e-citation system and the way in which it can be accessed. But beyond
You're not
that,
sure.
I have no knowledge of whether or not.
Okay, and so then the next question is, sorry, I don't mean to, you're doing great. I don't mean to jump on you. It's just what I do with everybody.
You are doing great.
And Mr. El-BAYEH, you did great too.
Pleasant experience.
Yeah.
And the rest of you lawyers out there, I know, will do great and always do great.
It's also not a pleasant experience. I apologize. But what I'm trying to get at is, is there, assuming the trial court had this amazing power to hit print and get physical copies, it's still, we need to sort out the problem that this is not in the record before us, and is it a fatal flaw that this, is it required that, you don't know the answer, was it required to have a physical copy in the appeal wherever he went, and if he didn't raise that specific question, maybe he did. You didn't assert waiver here, did you?
I did not.
Right, okay. Anyway, okay. Go ahead.
I want to turn to discovery because I do think that's a tougher issue for you.
Yes, Your Honor.
You basically said you didn't have any objection to giving him the manual, but you didn't do it, right?
Once the court denied his motion for discovery, the department did not provide any discovery.
And is there a difference between the training manual that the trooper was referring to and the guide for the piece of equipment? I mean, logic would say that there is, but...
There is a difference. What Trooper Sierra had in his possession on the day of the hearing was the training manual given to troopers about how to calibrate the device, the different types of testing that they can do, which he did testify to. One thing I would say, Your Honor, is that the LiDAR evidence in this case is not dispositive, even if the court
Well, but that's the
had not
problem.
considered-
You all have seen that if he gets a ticket, he's going to take every right he has. But you keep offering LiDAR evidence, and you could stop doing that, but you don't. So where we don't know, where the judge doesn't say, I'm not using the LiDAR evidence, I'm only relying on the trooper's testimony, which I find credible, I don't see how if there's a problem with the LiDAR evidence, we can affirm. Do you? Don't we
think-
have to go back and say you're going to have another hearing?
I don't think that that's necessary, Your Honor.
Why?
Because even if this court determined that the LiDAR evidence should not have been admitted, we would then shift to all of the other corroborative testimony that was given by Trooper Sierra about that it was 6:30 at night when he spotted Mr. EL-BAYEH speeding on a ramp on Route 3.
Oh, he definitely said that he was going at a very high rate of speed and that he thought he was going 75 miles an hour. But the problem is that we don't know what the judge relied on. So I don't know how if the judge had said, I find each of them independently supports that he is responsible for this motor vehicle infraction, then you would be correct. But where the judge doesn't say, and we have this arguably inadmissible evidence, then if we agree with him that it's inadmissible, how do we affirm? Because in the case you cite before where he lost, he hadn't challenged admissibility, he had waived that. And here, he's learning every time, see? And you guys are not learning, okay? Right? And so he's made a different argument.
But I do believe in the rescript opinion that was issued in that earlier case that Justice Rubin sat on the panel for that even though it was deemed to have been waived, the court did go into some detail about what additional evidence was offered to corroborate the LiDAR reading. That exists in this case too. It's almost identical circumstances really, where the LiDAR reading corroborated that he was traveling at a speed
Well, the LiDAR
beyond
was more
reasonable.
favorable to him because it was only 72.
Right, but also,
That's not more favorable. That's illegal also, right? Driving at 72 or 75, those are both.
Better
When the
than
speed limit is 55
75.
miles an hour, you
It's
should be
not-
driving at
but-
55 miles an hour.
He's guilty either way.
Justice Rubin's unpublished decision, I read all of his things, they're very important, but unfortunately...
As do I.
Unfortunately, it's not precedential, and I'm an independent thinker, and...
He is an independent thinker, my God.
I am struggling to understand the wisdom of that decision. And I agree with, here's my question. If we assume that the LiDAR was material to the judge's decision here, we need to make sure that it was calibrated under our precedent. Why not? And I looked far and wide for scientific evidence, reliable evidence of calibration through the method chosen, which was this fixed distance test. Now, I was an English major. I don't know about physics, but if we're talking about speeding, I think a fixed distance only gets us a part of the way there. We have to have something about velocity. And maybe I'm totally wrong, but there's nothing transparently obvious about why this fixed distance test that he used for calibration is reliable. I could be completely wrong. All I want is some basis, like a science article, to tell me that this was reliable and that the judge was reasonable to rely on it. I didn't see anything anywhere that, from any precedent or anywhere else, that the fixed distance test was a reliable method of calibration. That seems like a not crazy argument, that you need to prove to me that this is reliable. And it doesn't cause government to grind to a halt. It's just give me a science paper that proves this fixed distance test of calibration is reliable.
And maybe a photograph that shows how far the fixed distance is in the guy's house, so it's not 92 feet instead of 100 or whatever it is.
Assuming that is actually enough to prove that a speed gun is calibrated to accurately determine speed, which is a velocity, not a distance.
Well, I do believe that in Why Not, that is one of the issues that's addressed, is the scientific reliability of using,
And
in that case, radar.
Footnote 6 says that the self-tests, which is the other backup thing that they used
Which
here,
the trooper testified to having done as
there's
well.
disagreement. Now, that's a long time ago, 1970s, but the SJC in Why Not, Note 6 says, yeah, those self-test things are subject to disagreement, so reliability, the reliability of those is subject to disagreement, so we're not going to rely on that. Now, I was hoping, geez, that's a long time ago, maybe now they've made them better. And I have no idea, because it's not in the record, whether either the fixed distance calibration or the self-test are reliable. And in bottom line, if the LiDAR is material to the judge's decision, what evidence do we have that he properly calibrated it on the day he used it?
Well, I would fall back on the fact that the rules of evidence are relaxed in these types of appeals. Trooper Sierra did testify to both the self-test and the fact that if the self-test of the unit itself had failed, that he would not have been able to utilize it. It's like a stopgap measure so that members are not able to use them if they're not properly calibrated. He had done that in addition to the fixed distance test. And he does go into detail in the record about what it means to conduct that fixed distance test as well. And he does talk about that he is a certified operator and that he learned how to operate it at the State Police Academy and that he was trained to do one of these two fixed distance tests either at his home or at the barracks, as well as the self-test. He's checking every box for what he needs to do in order to ensure the accuracy and reliability of the reading.
I hear all of that. The problem is he's checking every box. The box to him, I think, and to me, is a black box. In other words, he's doing what he's told. He's doing all the things he's told to do. But if you ask him, why is this reliable, he doesn't know. I mean, I'm not blaming him. I don't know either. I think the way this is supposed to work is when we use science, we're supposed to have some scientist tell us why it's reliable. And that's like...
Are you saying basically that because Why Not essentially did that? It said this science is reliable, albeit radar, and this is a little different, that covers this situation?
Well, that in conjunction with a large portion of my briefing was based on the court's ability to take judicial notice of the accuracy of the scientific reliability.
There's never been a Daubert-Lanigan hearing in any case in Massachusetts about LiDAR, but you want us to take judicial notice because other states have said it's good?
There has, not that I'm aware of.
Shouldn't there be at least one time that scientist comes in and tells a Massachusetts court what the hell it is? I mean, Judge Henry said, it's a little different. I have no idea. It's laser, not radar. It doesn't, I don't know what that is.
Well, the letters are different at least.
No, but
Well, it seems totally different.
No, but your brief catalogs cases, and this is an important distinction. You catalog cases where other courts, I have no problem with other courts, other states, they're good too, say that LiDAR is reliable.
Many of them.
But they don't talk specifically about the calibration. It's one thing to be a reliable technology, but like all technologies, it can fall out of calibration. They agree with that. Everybody agrees with that. It might not have been calibrated correctly on that day. That's why we need to figure out if the calibration that was used that day is reliable. That's my question. It's a different question. LiDAR can be a reliable, radar is reliable. The question is, on that day, was this reliable technology working correctly?
And what I would submit, Your Honor, is that that's what that self-test safeguards against. That self-test will not allow a member to use that LiDAR device if it is not.
Is that in the operator's manual? How do you know that the self-test is any good?
Because
the trooper says it is.
Trooper Sierra testified.
Boy, that's
testified to that being.
And his
the training
PhD is in lasers or radar or both?
It
It might well be,
That should
but
be in the
that's not
record.
in the record either.
But just to back up, because you do challenge the relevancy of this evidence, the discovery that he sought, and I think his point is to challenge the foundation for the admission of the LiDAR evidence. So why wouldn't that be relevant for the reasons that my colleagues are pointing out?
What I would say, Your Honor, is that while the rules of evidence are relaxed in these types of cases, as you know, under the uniform rules as well as Chapter 90, Section 3, the one commonality in both of those sources is that there needs to be a showing of relevancy in order to gain discovery. That is the bare minimum that needs to be shown.
How can measuring the distance at the self-test not be relevant?
My suggestion, Your Honor, is that when Mr. El-BAYEH was pressed by the court regarding what the relevance of this particular discovery would be, he didn't say anything about the accuracy of the device itself. Instead, he suggested that perhaps the device didn't exist, that it was a different device that was used.
Okay, those are all good questions.
I don't think
Does it exist?
I don't think that forms the basis for him to receive.
In a
the
criminal case, it probably would.
But this isn't a criminal case.
No, I hear you, but it has to be accurately determined. Your time is up. I have a few more.
Well, he's arguing the standard of review on the LiDAR evidence being whether it was admissible is prejudicial error because he did make many objections. What do you think the standard of review is?
The standard of review would be an abuse of discretion by the district court judge in denying or overruling his objections.
And we have no published case from any appeals court saying what the standard is for getting discovery in a civil motor vehicle infraction. We just have this test from the appellate division.
We have that, and what's contained within the uniform rules and Chapter 90, Section 3, I think does touch upon access to relevant evidence.
Okay, I want to go back to the original motion to dismiss case, because I think if it should have been dismissed, that would moot the rest of this case, which isn't to say it should have been dismissed, but I just want to make sure I understand. The citation is sent to the magistrate, not to the appellate division, presumably.
Presumably.
Okay, right, because no one knows if there's going to be an appeal. It would be odd to send it to an appellate court that doesn't
Yes.
and may not ever have a case. So it's not sent directly to the judge in this case, or the court in this case. The uniform rule says that when the appeal is, I don't know what the right word is for when it's done by a magistrate instead of by a person, but like entered or sent or something to the court, it's supposed to have this thing front and back. Before the hearing at which the trooper testified began, am I correct about this? Mr. El-BAYEH moved to dismiss because there was no complaint. And it was only after that portion, during the hearing portion, that I'm not 100% on this, and maybe the transcript will show it, and I just haven't looked at it. Is that right?
I don't recall
Okay.
a motion to dismiss for lack of complaint.
Okay, I think he says something like that, or lack of probable cause, because there was no complaint or something.
There was a motion to dismiss for lack of probable cause related to the citation not being in the record.
Yes.
And then there was a secondary argument regarding the no fix statute.
Okay, but that first, this is before the hearing on the merits.
I believe, yes.
Okay. Why wasn't he right that there was no citation and therefore it should have been dismissed? I understand in terms of finding of responsibility you have some evidence, but there was nothing in the record at that point.
About whether or not a citation had been admitted?
And about this, and the citation itself wasn't there as required by this rule.
What I would point your honors to in the record appendix is all of the documents and paperwork related to his appeal at the district court level, from the clerk magistrate's hearing to the de novo hearing. All of that paperwork contains all of the information from the citation.
Did you ask to have, is that in our?
That is in the record appendix.
We have
yes.
everything the judge had on the bench at the time she ruled on this
That's my understanding, yes.
motion? All right, I'll have to look at that. Question about the videos. Did you submit videos?
I did not submit videos, Your Honor. It's
Wonder
my
what these
understanding.
videos are. Yes.
My understanding that Trooper Sierra, during the hearing itself, presented his laptop and I believe played the body-worn camera footage for the court to.
And that wasn't entered in the record?
It was not entered into the record.
Well, the judge watched them.
That's right, but by not entering in the record, they may not have created a record that we can that's adequate for our review? I don't really know.
Other than what was in the transcript where the court is narrating.
Yes, I mean, I had a case
observations.
recently where a judge, in issuing an order, looked at a bunch of things on someone's phone and never described them on the record, didn't enter them, right, and there was there was nothing for us to look at. All right, but so your point is there is nothing for us to look at, and you don't know what these videos.
You didn't enter anything in the
No, and I when I was checking the docket, I believed that it did say a CD-ROM had been sent, I thought by Mr. El-BAYEH. I don't know if it was another item that was sent by the court, but it did not come from the state police.
I take it his position is that he didn't submit any video evidence. Oh,
That was related to the single justice motion.
oh, I see, they were in the single judge, okay, all right, okay, I see. All right, the case is interesting and submitted.
Thank you all
And you've
very
both
much.
done a great job.
Thank you very
So,
much,
thank
Robert.
you for helping us with your arguments.
Thank you.
We are going to take our traditional mid-morning break. We'll be back in 10 to 15 minutes to hear the next case.
There is a session, please be seated.
Good morning, welcome back. The next case we will hear, assuming I'm not mistaken, is number 25990. This is CRUCETA versus J.C. CANNISTRARO, LLC. We will hear first from Mr. CRUCETA, and I'll tell you the same thing I said to our last pro se litigant, which is we know you're not a lawyer, and this may be intimidating or difficult, but we don't mean to be, and we're going to try to make this as comfortable and straightforward for you as possible. So, with that, it's your time.
May it please the court, I'm Ramon CRUCETA pro se. This appeal challenges a summary judgment entered after proceeding that was denied a fair opportunity to be heard, excuse discovery violations, impose legal requirements that do not exist in Massachusetts law, and resolve materially disputed facts against the non-moving party. The summary judgment hearing itself lasted less than 12 minutes, and the court dismissed this case despite unresolved factual disputes that should have gone to a jury. The court also will start with the privilege. Privilege was waived, and the court ignored controlling Massachusetts law. CANNISTRARO asserted attorney-client privilege without producing a privilege log. I mentioned this to the judge several times. He waived that right under Massachusetts law because he had already provided me emails from Regina McGregor. I showed those emails to the judge, so therefore he couldn't claim privilege because he already waived that. Massachusetts law settled on that with Electric Mutual, Hanover Insurance, and Comcast, which prohibits selective discovery. So voluntary disclosure waives privilege. But
Can I introduce? I usually like starting at the beginning and going to the end, but sometimes you got to start at the end and go backwards. And to me, this is one of those situations. Damages. So without damages, you don't have a case. And so in your situation, your opponent makes an argument that I think is a pretty good argument that I'd like to hear your response to, that to the extent you have any first of all, you have no evidence that your identity has been sold to anybody. You've actually, that it's, I understand your argument is that the damage is when it was put onto the dark web. It's out there. But you have not been a victim of identity theft in the sense that you have suffered any financial harm. And you also, I think, agree that you in the deposition or interrogatories, but you said, I have no physical injury. And so you have to, if you're alleging emotional damage, I think you have to allege physical injury. What do you say to that?
well, to answer your question, damage was done when they breached when the breach occurred.
Right,
That
so
is-
let's say I disagree with that.
Okay,
And I know
that's a
it's
good
rough,
point.
but let's just say I disagree with
Well,
that.
that's a good point. There's two kind of damages that we address if you read the appellate. My concern isn't about the guy who's trying to take my credit information and charge up credit cards. I'm concerned about the criminal that's trying to take my identity, who's a fugitive from justice, who's trying to become me,
Right.
which I included in my report. There was a guy, I forget it was Utah. He stole somebody's identity, worked at a hospital for 16 years. That guy got arrested, ended up going to jail. There was another guy who stole somebody's identity for 30 years. There's three types of identity thieves. There's the one that takes your identity to buy products to sell, to get high or whatever. There's the one that takes your identity to build up credit, to get more credit. Then there's the guy who wants to become you.
Okay, but I think what Judge Wood is saying is this. So, in everyday language, of course, that's damage. The fact that you have to worry about something is damage. The fact that your thing was stolen is damage in the sense that every time it happens, maybe they have to by law, the company sends you a letter and says, we'll give you this free Experian, credit monitoring or whatever. So they recognize that that risk is, in everyday language, a kind of damage to you, and it causes worry and anxiety and stress and that kind of thing. But then there's the kind of damage that a court can remedy with money. Now, emotional distress in Massachusetts can be remedied with money, But there's a rule. I'm not saying I agree with it, but I don't make the law. You know, we have to apply the law. There's a rule, I think, at least in some cases, that says, unless you're physically injured, we're not going to compensate you for emotional injury. Now, maybe that's a rule because they think people will lie about emotional injury, or maybe, I have no idea, but that's because people often suffer emotional injuries without being physically injured. But if that's the rule, there is no physical injury here. Do you think that's the rule, that you have to have physical injury, or no?
Webb versus Pharmacy, which is a First Circuit case, ruled that exposure is harm in itself. I believe this court is bound by that ruling, right?
We're not bound by it, but because it's a federal law, but it's persuasive.
And that's the most recent ruling.
Okay, so I agree that your opponent has not cited the Charlie part of the Webb case. But in the Charlie part of the Webb case, I think it said that she had, in addition to all this, she had spent some little amount of money or something trying to fix it.
That wasn't what the ruling was based on. The ruling was based on the exposure itself was harm, if I'm not mistaken.
I'm going to have to look again. Because I did look at, I looked at that case.
Did you spend any money to try to deal with this?
Here's the thing. The only reason why I found out this breach occurred because I already had credit monitoring services already. I was monitoring my credit. I was about to buy a house. And if I didn't have that monitoring service, they would have got away with this crime. This was a complete cover-up. They lied to the FBI. They lied to the Attorney General. 1,419 people were affected by it, and therefore they tried to cover it up. So if I didn't have that experience, so when they offered me this service, it did me no justice. I already had it.
Right, but so Justice Henry's point, though, is did you spend money out of your pocket that you weren't already spending to deal with this? That would be a kind of injury that we could count.
If you look at Ramirez versus TransUnion, it's clear on that. That's another federal case that I cited. But back to what I'm saying here, my case was improperly ruled by allowing him to get away with claiming privilege without a privilege log. If the court allows that to get away...
Are you familiar with the idea of work to rule?
What is that?
Well, like in a lot of companies, right, there's like, 50 things you're supposed to do, but in practice, in the day-to-day, people don't do all 50.
That's a law.
Close.
Could you imagine if the court allowed every lawyer to say privilege without claiming a privilege log after they waived the right? You know what kind of precedent this court would set?
I think the issue here is that you're seeking emails from the general counsel and
that he already provided to me. That's the same subject matter.
The thing that I saw that you cited in the record was an email to all employees notifying them of the data breach, but that's not a waiver of privilege.
He never notified me. That's a fact. That's something that should have went to a jury because we dispute that. He says that they notified me. I said they didn't.
You're saying that there was that you saw some emails from the general counsel, and so there was a waiver of privilege. I understood that's what you're saying.
That's what the law says. I don't make up the rules.
No, I know, but then I want to know where in the record that email is, because the email you cite to us that I went and looked at was... Okay, well, so can you give us the page numbers, because the one I saw was...
I don't have them offhand right now, but you guys have the record.
But you say they're in the record.
There are 3 emails, they're on the completed record. I argued this in front of the judge. The rules say that once you give privileged information, you waive it. I'm entitled to, you can't selectively pick and choose what you're going to give me. I didn't get a proper chance to get the discovery because he was holding evidence from me. And then when the judge ruled that I could get, if we talk about the judge ruled that I could examine Exhibit B, which I believe was forged either by CANNISTRARO or their counsel.
That's the WISP document, correct?
Yeah, the WISP document.
And that's a one-page document?
One-page document, right? The judge ruled that I could see that. Then when he refused to comply, I filed a motion to enforce, and the judge denied the motions because he said I needed to be an expert to look at a document that's simply going to tell me whether or not he conducted the inspection or not. Not technical computer language, not computer science, not whether or not the inspection was conducted. That is another violation that he did. He also misframed the case as a negligent infliction of emotional distress, which was never pled. So he based his ruling...
Can we stop there and just pause for a second? Negligence. I think, so you say it's not negligent infliction of emotional distress. I think what you're saying is that it's actually, because I looked at the complaint, it's actually negligence.
It's negligence, correct?
Right. So the problem is that's not really, that doesn't convince me. So, and you have to convince us, unfortunately. It's not a fair system, but you have to convince us. Right, so hold on, let me finish my question so you can answer it. Negligence, where the damage is emotional distress, is negligent infliction of emotional distress. You can't get around the requirements of negligent infliction of emotional distress by saying it's just negligence unless you have a damage that is physical or financial. So what's...
I've never pled negligent infliction of emotional distress.
That doesn't matter. That's not the
way
way
it ruled on that. He said that that's what I pled.
Right,
I didn't.
but when
I
the
pled
question...
negligence, fraud, and invasion of privacy.
So the elements of negligence
Yes.
include harm.
Yes.
And that you have to prove, you have to allege harm.
Well, if you read the totality of the record, you're going to see that they were warned by their cybersecurity provider 17 months before the breach occurred. The guy that's in charge of that ignored those emails. They were out of compliance for 17 months, violating 201 CMR 17.00.
Yep.
Then the same vulnerability that they warned about was the same place that they got hacked. So this was negligence on their part because they weren't in compliance with Massachusetts Code of Regulations.
I don't have a problem with any of that.
So
I understood all that.
That's not negligent. The law states
Right,
you're supposed
right,
to check. You're
right.
supposed to
Okay,
check
but
your
the
security
problem, though, is
systems
that
every 6 months.
People get hurt by things all the time, so the law tries to have a balance about when there's compensation available and when there's not. And
My
so
social security is on the dark web forever because of their negligence. It
I
should
know,
be
and
reckless
and
negligence.
unfortunately, and I share your frustration because we're all getting data breach notices regularly. It doesn't seem like many people can keep data secure. I get it. I've gotten the exact same notice. But what the thing is you have to come up with some damage. And right now, whether it's wrong or right, there's an issue whether the law will just provide you compensation because your social security number is on the dark web. And he's saying you need to have some sort of provable damage, not just this notion.
Well, let me ask you this. I was robbed of the evidence that was entitled to me because they refused to follow the rules of the court. So now you're telling me we're talking about damages when the case was incomplete from the beginning. You have an incomplete record because the judge ruled on something, then denied his ruling, allowed him to get away with a privilege claim. If you guys want to set the precedent that you can just claim privilege without law, then that's what it's going to be. But I'm just telling you that he violated the rules of the court. This was supposed to go to trial. He was supposed to provide a privilege log, and he didn't. Those emails from Regina McGregor, I am entitled to that evidence.
Right, so let me pick up on that and sort of reframe what you just said. Accepting that that's all true, that there's something important to the negligence piece, just wait a second, let me get the question out.
Time is wasting here.
This is the way this works. We ask a question, you answer it. That assuming there's, the privilege log has important stuff in it that goes to negligence, that isn't going to go, as far as I can't figure out how that's going to go to the other part, harm. You know the harm to you. I can't figure out how anything in that privilege log is going to explain the harm to you. What's the harm to you?
The judge, I think it's Judge Tabbitt, he told them at our hearing, Rule 16, that your exposure to the internet, right, is traumatic whether or not somebody uses it or not. Then they told me to list down all the symptoms, which you guys have on my amended complaint, what I'm going through, the emotional stress. Every day I'm worried about, am I going to be the police going to come knocking on my door and arrest me like the guy in Utah, pretending that they're me? You guys are under the impression that you think that harm. My argument is the harm occurred once my information was on the breach, and they broke the law. They were supposed to notify me immediately, and they waited 70-something days to notify me.
I'm very sympathetic, but unfortunately, we're just applying the law here, and the law tells us that where there's a negligence claim, you have to articulate a harm, and if the harm is emotional distress, as justifiable as it is, we have a new rule, another rule, an additional rule, which is you have to allege physical harm or you have to allege financial harm.
Under what statute is that? Because the most recent ruling in the First District is Webb versus Pharmacy, and you should look into that because that totally contradicts what you're saying.
I have Webb in front of me, and you are at least partly right.
Okay.
That the holding of it with respect to Charlie is, there's a footnote that says we don't hold that just because there's a risk of future harm that you have standing. They say in light of plausible allegations of some actual misuse, that is, against Webb. No one misused Charlie's information, at least yet, in this. The complaint plausibly alleges a concrete injury in fact, based on the material risk of future misuse, and so forth. Is there any evidence that anyone from this data breach has suffered any harm, even someone opening a credit card in their name or anything like that?
Well, I had to go to court, and it's on the record. You guys see, I had to go to court and fight 2 credit card charges, one for $5,000 in Lawrence Court, and the other one was for $2,000. We argued out in court. I showed the judge the document right there. That's all on the record. That I ended up beating those cases, but I had to go to court for that because somebody rang up some credit charges under my name and saying I had a dog, and I don't even own a dog.
So you presented that to the trial court before this was dismissed?
Yes, I presented that. It's on the record. I presented that to the judge. He wanted to see it. I gave him that.
Okay. We'll look at that. Now, your time has expired. You've done an excellent job, by the way. I mean, I think we understand your arguments both from your brief and from your argument here. And, you know, the law turns out to be a little more complicated than some other parts of life. But I do think we understand your argument. And we do look and will look carefully at everything you've told us. So
Well, I appreciate that.
thank you very, very much. We will hear next from...
May it please the
Dubert, is that right?
Dubert, Your Honor. May it please the court, Chris Dubert for the appellee, J.C. CANNISTRARO, LLC. I have a couple points I want to make, but I'll start by addressing some of the things that were said and some of the questions you had. Justice Henry, with regard to the appellant's request for emails involving general counsel, as you noted, the email in the record is an all-staff email from the general counsel to staff. We're not alleging it's totally irrelevant whether Mr. CRUCETA received that email. The point is, for the discovery purposes, that was not a privileged email. His argument is relying on the fact that he thinks every email from an in-house attorney to employees at that workplace must be privileged, and therefore by disclosing that email, we've waived the privilege.
I think we understand that. The question I was trying to ask then is, are there other emails besides that email in the record?
I do not recall specifically,
Okay.
but I can tell you for sure, to the extent there were, they are not privileged communications. They may have concerned business, may have had third parties on something of that nature.
Okay, but it seems like a key fact here is whether or not the company was told you need to patch your software and before this data breach. And I can't, your brief is, I respectfully, a little slippery on that. And he's saying you had notice, and I don't see you agreeing. So is that a dispute?
Well, I think that gets to the central point of the trial court's opinion, which was you need an expert to opine on that.
No. If your vendor, you're going to have trouble getting me on that. If your vendor says you need to patch the software, you don't patch the software, and you have a data breach, I don't know why you need an expert.
Because you don't know whether that patch would have fixed that issue. You need someone to draw. There's an allegation. The allegation would be that J.C. CANNISTRARO.
There's sufficient evidence from we have warnings sent by Fortinet or whatever that company is that specifies what the patch is and says it will fix it. This is a civil case. Surely that's sufficient for a jury to find that it would have fixed it? No?
Respectfully, I disagree, Your Honor. That certainly requires scientific and technical knowledge.
Well, it might require calling in the person who wrote the flyer.
I'm sorry, say it again?
It might require calling in the person who wrote the flyer. Maybe it's hearsay and can't come in without the actual person. I don't know about that, but it suggests that there's, from that, maybe it's not discoverable admissible evidence.
You still need someone to.
There's also an email from someone at your company internally saying this was a known vulnerability.
There's a couple things there. One, there's internal communications, which was Exhibit 10 on the motion for summary judgment briefing, which is internal communications between IT individuals disputing some of these technical elements. And so in this case, he would have to prove both that what CANNISTRARO did with regard to let's say not updating its firewall here, was negligent, and then also that negligence caused the data breach at issue here. And
Well, he has some evidence of each of those things, right?
there's no evidence that, we don't know what the established best practices are for updating
You think
firewall.
not updating your software is the established best practice? I mean, we all I mean, at some point, this is not,
That may be,
at some point, certainly this will not require an expert. I don't know if we're there yet or not. But at some point, we all do this all day long. We are told warnings from, in my unfortunate case, because this is what our court uses, in Windows, we're given warnings like, get this update, get this patch, important security breach. I have it automated, but if you don't have it automated, you get a warning telling you to do it. And I think we all know that you do it, and I think we all, maybe this is wrong, but I don't know that this has to be shown. Maybe these patches don't fix the security problems. I don't know.
but to your very point, the ubiquity of which you receive these notices does not mean that an IT professional has to jump at every single one. Some may be more important, some are more relevant, some they may appropriately disregard.
Although we have an
an
internal email here that says the name of the vulnerability, CVE something. Okay? So I guess that was an important vulnerability because that's the one that led to the breach. Now, if we read the statement about what it says it could lead to, and I don't remember exactly what Fortinet says about each of these because it mentions there are several of those notices. I think maybe they're all about the same thing. I don't know. But I mean, the question is it adequate to go to the jury? That's right. Is there an adequate foundation without an expert for this?
Your Honor,
And I'm not sure what the answer to that is, but it doesn't seem obvious to me that you need an expert to testify you should really, update your software.
Honor, respectfully, I think you just sort of said something very important. You said you guess that it would be that someone would have to do this, but you just don't know. And at some point, on issues like this, you need someone to say that what CANNISTRARO here did by not updating this software in this patch at that time caused this data security incident. There's nothing in the record that establishes that.
Let me ask you about standing and really about the web case. So, first of all, Mr. CRUCETA says he had unauthorized charges on his credit card.
Yes.
Is that in the record?
Absolutely not. It's in no pleading. It's in no document in the record. It's not in the record appendix. It was never.
Is it in the
anything
transcript?
before. I'm sorry, say it again?
Is it in the transcript?
No, Your Honor. This is a made-up thing today.
Well, we'll look and see if it's made up. I mean, I haven't been seeing a lot of made-up stuff in his filings, but we'll look.
I'm going to go back, though, to what I asked you, which was, does the record show that you had noticed that you needed to patch your software? You can argue about causation all you want, but did you have notice prior to the data breach?
CANNISTRARO received a notification from Fortinet saying, please update this software.
Before the data
Yes.
breach? Okay.
Right, I'm going to try and link this a little bit more. Same question, really. I'm reading from the judge's order, Judge Saroof, I guess granting summary judgment. This vulnerability, I guess this is from Fortinet. This is not a quote, but this vulnerability was fixed in 2019, and customers, I guess, CANNISTRARO, were notified through blah, 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 were notified. It wasn't clear to me when the customers were notified. I think it's the same question. Is there anything in the record that tells us when Fortinet notified CANNISTRARO of this 2019 fix?
I believe, yes, there is. I don't have the exact date, but there is an email in there that will show the email from Fortinet to CANNISTRARO's IT people.
And was that in the close in time to the fix? In other words, in 2019?
I could look, but I respectfully, I don't think it is, no.
Okay, all right. Okay.
And so to that point, we don't know whether there were subsequent patches, changes in the software, other things that CANNISTRARO did or didn't do, which may have contributed to this data security incident.
Okay.
But these notices or articles that are in the record do seem to say that the vulnerability allows an unauthenticated attacker to download the system files.
Understood, Your Honor,
So
but,
I'm
but that still does not make the bridge of causation to this specific incident. Data security incidents are caused all the time by all kinds of threat actors through all kinds of software. Someone would need to opine that CANNISTRARO's inaction here caused the data security incident at issue here.
No, not that it caused it, but that it allowed it to happen, that it was foreseeable that it was going to happen.
Fair enough, Your Honor. There's no evidence of that in the record. You would need someone with scientific and technical expertise to make that connection.
Yeah, you're losing me on that. I mean, anyone who has any kind of data that allows someone to log in knows that there are threat actors who want to come and get your data. Like, whether it's the bank card I have in my pocket or anything else, people want that data and you want to keep them from getting your data.
Understood, Your Honor, but I don't think we can know what no one knows what that Fortinet software patch would have necessarily done related to this incident. I understand at a big picture why conceptually that makes sense. You still need to draw a connection between that alleged failure and the data security incident at issue in this litigation.
I think he's also arguing that two-factor authentication also could have prevented this.
That is for an expert to opine on.
Well, if you don't have the second factor, you can't get in, right?
I don't know, but we have no idea whether two-factor authentication here would have prevented the data security incident at issue. These are important questions. They are things that would be opined on by an expert and evaluated at that stage. That didn't happen here in this case.
All right, so he's arguing that, leaving aside the negligence claim, that he had a claim under Chapter 214, Section 1B for invasion of privacy, and that doesn't require physical injury to provide damages. What do you say to that?
That statute says protects against unreasonable invasions of privacy. Again, so a reasonableness element, we would have to evaluate CANNISTRARO's IT policies and practices.
But you agree it doesn't require physical injury for emotional damages to be recoverable?
Yes.
So on a summary judgment, it seems hard, reasonableness is a hard standard to satisfy on summary judgment. If there has to be no dispute that this was, are we on summary judgment? I apologize. We're on summary judgment.
Yes, summary judgment, yes, Your Honor.
Right, and so there can be no reasonable dispute that this was unreasonable invasion of, there was a chance of an unreasonable invasion of privacy.
Well, I think under the normal, as would be the case under any summary judgment, that would create a very difficult burden for the movement, for the defendant. If he puts in an expert that says these are the normal policies and practices and the defendant didn't follow them, and whether they want to put in the report or not, by not following them that wasn't reasonable, I think there's a very good chance that establishes a genuine issue of material fact and survives summary judgment. But that did not happen here.
So how did you get that one dismissed?
Sorry, say it again?
How did you get that count dismissed? It couldn't have been dismissed on the ground that you needed physical damage and no standing, right?
The trial court evaluated everything generally under the umbrella of whether there was sufficient, whether expert evidence was needed to move the claims forward.
So that's the only basis. You don't argue stand.
Well, I have three independent bases for which you can affirm the trial court's decision. Okay. One is his failure to comply with the rules in terms of providing a complete appendix. He absolutely was far off from there.
Okay.
And you
didn't you also have to refile something? Wasn't there also, yours was non-compliant?
We had to repaginate, but we filed the required documents. He did not provide.
I haven't yet dismissed an appeal. It's not up to me by myself because the appendix was no good. I mean, people have lost because the appendix is no good. But
understood, Your Honor. But there are many decisions from this court in which such cases have been decided on that basis.
All right.
And then otherwise, there was the genuine issue material fact, and then there's the absence of standing. Those are three independent bases on which this court can affirm the ruling on summary judgment.
All right. So, and the third one is?
The absence of standing.
So if you don't need to show physical or economic injury to get emotional damages from the invasion of privacy, why wouldn't someone claiming emotional damages have standing? I'm not saying they win the case or anything else. Why wouldn't that indicate standing?
Standing, so we have two common law claims here, and then we have the statutory claim. So standing under Massachusetts law requires proof of an injury and then plausible traceability of that injury to the alleged harm. And then a statutory cause of action requires the additional element that the claim be within the zone, you know the law better than me, the zone of interest that the law is trying to protect. He cannot meet that first part, which is establishing an injury. There is no injury.
Wait a minute. You just said that emotional injury is compensable under invasion of privacy. Is it not?
No. It is not. It is in Webb because there was the other plaintiff.
I understand about Webb. I'm asking about the invasion of privacy cause of action. You've said there doesn't have to be physical injury.
There still has to be injury, which would either be financial, which there is none.
There has to be economic injury or physical injury?
There has to be some kind of injury.
Okay, but I think we can all agree that emotional distress is some kind of injury. Sometimes we compensate people for it. Are you saying that emotional distress is inadequate in an invasion of privacy case?
Yes.
Do you have a case for that?
No, I don't, except for I think it flows from the general standings of standing generally. There are other cases, I should say, I don't remember, I could look at them, that have dismissed multiple Superior Court decisions dismissing in data breach privacy cases causes of action for under that statute.
So going back to this document that's garbled, right, because stuff is written over, this WISP document, why can't he be allowed to see it? I mean, to see, you just look with your own eyes, is this tampered with?
I'm sorry,
You were ordered to provide the WISP document, Exhibit B.
Okay.
Right? And you give a copy of it. And
Your Honor, I did not brief this issue in full because his description of it is so inaccurate, it's difficult to respond to. It was not in the notice of appeal and is not properly before this court. The WISP document, what it is WISP, Workplace Information Security Protocol. You can send that to vendors, and then they sign a document saying, we agree to abide by this, right? So the Exhibit B that he's complaining about was signed by a vendor electronically saying, yes, we will comply. We produced this document. It has no relevance to this case whatsoever.
But I thought you were ordered to provide a WISP document in this case.
We provided that document. We provided the WISP. We provided that signed document. He alleged that it was fraudulent or that I signed it or someone signed it.
It's written over. It says on behalf of, name of a company, and it looks like it's supposed to say I hereby certify, but the hereby and the certifier are on top of one another.
Yes.
It's just that I've seen a lot of these documents. And then other lines later, like there's an and like a TH that's sort of messed up, and then the fourth line down it says are in compliance with, it's supposed to say these requirements, but something's typed over that. And then there's the next line, granted, it looks like somebody typed over that.
Yes, so what happened, and we submitted a declaration on this issue to the court explaining what happened. Sometimes when a document is electronically signed, the font gets messed up. We produced the original Word version. We produced a declaration explaining, look, we sent them this document. We produced the original email sending the document that did not have any of those typographical errors on it to this third-party vendor, and then produced the email coming back, which he signed with the typographical errors. It's a technological problem that has no relevance to this case whatsoever.
Is that declaration in the record appendix?
No, because it's not relevant to this issue. It was not on appeal.
Well, what if we disagree with you about that?
I mean, notices of appeal, I think there's some question about how and whether they cabin things, but go ahead.
I just want to emphasize that there's nothing even remotely there that would establish a material issue of fact or would be otherwise relevant to any of his causes of action whatsoever. The judge's opinion on that is not in the record. The judge's, the documents on that issue are not in the record.
I'm looking at his Appendix 16, and there does seem to be this order that if the WISP forms do not exist, an affidavit of a designee of defendant stating so shall be produced, and it sounds like they did exist, so you produced something
Correct, Your Honor.
different. It literally even says production forms, WISP forms It says or inspection of same. I think that in.
We complied with that court's order. He complained about it, and the judge says, no, they complied.
But we don't have that, we don't have that
Correct,
in
Your Honor.
the record appendix.
Correct.
All right, you're well over time, but that's not your fault. That's our fault.
you, Your
So,
Honor.
thank you very, very much. These are very helpful arguments to us, as always, and very well done, both of you. Thank you. The next matter that we will hear is Delgado Juarez versus Giblin, number 25440. We will hear first from Attorney Cassidy.
Good afternoon. My name is John Cassidy. I represent the defendants, appellants, Dr. KATHRYN GIBLIN and the Massachusetts General Hospital. The trial court's errors in this case allowed the jury to be misled into believing that the testimony of Dr. Eichler, the so-called or purported missing witness, would have been unfavorable to the defense. It further allows the jury to conclude that there was a willful attempt to withhold or conceal significant evidence in this case. Neither of those things is true.
The instruction was given with respect to both parties. So first they'd have to find that you were the party that would have naturally called the person, right? Because they could have found that, in fact, it was withheld if it had been so helpful that the plaintiff would have put it on and that it was they who were hiding Dr. Eichler, right? They didn't say, the instruction didn't say you, it said you may draw an inference against either of them.
Right, it did, but, Your Honor, I think that underscores that I wasn't able to find any case, Your Honor, where a missing witness instruction was given with regard to both parties. And as I argued...
It's got to be less damaging than one given only with respect to you, right?
Possibly, possibly not, Your Honor. But the point is that the fact that the judge gave it supposedly neutrally as to both parties really underscores the fact, and this is the law, as I understand it, in Massachusetts, based on the Hoffman case, based on the Alves case, that where the so-called missing witness's testimony may be favorable in some ways to both parties, the instruction should not be given. And that is absolutely the case here.
Is that in your brief?
Your Honor. Excuse me, Your Honor?
Is that case in your brief?
Yes, Your Honor. Hoffman is in our brief. Alves is in our brief. Anderson is in our brief. And
Sorry, I feel like you need to reset this. This story begins in the opening statement. The opening statement, you guys made this all about Eichler. You guys said that the core of the defense was, I'm just the resident, Dr. Eichler is the attending, he's the one who told me to do this. He's the one who said give 25 milligrams to the 60-pound 13-year-old, even though 12-year-olds are supposed to get 4 milligrams. He's the one who approved that. And the whole case is Eichler made me do it. So how can you, but that was your choice. And I don't mean you, maybe it was the trial, I don't know if you were the trial lawyer, but your side's choice to do that. How can that not be an issue that the court needs to address?
Well, Your Honor, several things. Thank you. I was trial counsel. And firstly, Your Honor, that was not the principal defense in the case. That was not the core of the defense, if you will.
The jury rejected the core of the defense. We were following FDA regs. The FDA told us that when you're 13 or over, I know the core of that defense. The jury rejected that defense. The jury said it was medical negligence to give a 13-year-old 60-pounder 25 milligrams, no matter what the FDA chart said, right?
Well, we don't know that, Your Honor. Respectfully,
Well, they
the
had
jury
to have.
doesn't,
They
the
found
jury
for
doesn't
the-
deliver an opinion, they deliver a verdict. And in fact, the fact that the missing witness instruction was given in this case, Your Honors, poisoned the entire case. And for all we know, the jury could have decided that Dr. Giblin was negligent because they believed.
Okay, so
May
sorry,
just finish this?
I hate
May
to interrupt,
just-
but here's the way I'm thinking about it. The way I'm thinking about it is that you put this question before the jury. Eichler gave this is Eichler's fault, and Eichler's not here. That's the defense. That's one important defense. And, well, you can shake your head, but that's what I think. I think that was the whole point, and that's also what the judge said. The judge said, you are pointing the finger at Eichler, and Eichler's not here. You chose to do that. So how can you now say that it's inappropriate, an abuse of discretion, to give a missing witness instruction?
Because, Your Honor, I believe that under those same cases, Alves, Anderson, Hoffman, it is an error of law, not an abuse of discretion, but an error of law if the court misapplies the foundational requirements for a missing witness instruction.
Okay, which foundational requirement did the court misapply?
Sure. The court misapplied the fact of cumulativeness.
Okay, let's stop right there.
Yeah.
Because that's the one you actually articulated at trial. I mean, whoever the lawyer was, maybe it was you for everything in the case, the first answer was, I don't have to. That's not a reason. The second was, I don't want to. Well, that's a reason, but it doesn't tell us anything about the reason, right? And I don't need to. Maybe that's cumulativeness. How can it be cumulative? Here's who you put on to talk about whether Dr. Eichler approved of this. Even leaving aside the deposition where he says he doesn't remember the case, doesn't remember approving it, doesn't remember not approving it either, but doesn't remember. You put on, you argued it. You argued he approved. That word shows up, I think, only in the opening and closing arguments. You tell the jury he approved it. Dr. Giblin testifies that they worked together as a team. She would never have prescribed this but for her consultation with him. She never quite uses the word approve, but she essentially says that's the way this, I mean, she also says it has no recollection of the case, but there is a case note saying she discussed it with Eichler. And that's what happened. That's her statement. Then, instead of putting Eichler on and saying to him, is that how it works at whatever hospital this
Mass
is?
General, yeah.
Is that how it works at Mass General? The resident can't prescribe without, isn't supposed to prescribe without checking with you, and you're the attending, and all they are is a resident, and they report all the stuff that your expert said. You don't ask him, you ask some expert. How do things work? Oh, well, they work like this. Residents do this, and attendings do that, and so something like this, under the ordinary practices of any fine hospital like the Mass General, it would be approved by the person. How can his own testimony of what he did or didn't do or does do or his practice be cumulative of some generic statement about how at good hospitals these things work?
Because, Your Honors, it was not only Dr. Peters, our expert, but it was also Dr. Giblin. And
okay, I agree, but the question, it's not asking him, oh, by the way, did you approve this?
But that's
is different from that. Now, we know also that he said, or we don't know, maybe his position changed. I don't know why you didn't call him, but assuming his position stayed the same, he would have said, well, I don't remember this case, but you were allowed to ask about general practices. Do you do this? Do you do that? Did you do it during the year that she was there? Did you, right? That's different from someone generically saying, this is what people do.
Well, I disagree, Your Honor. the jury heard from 3 different people, including the plaintiff's own expert, that this is the generic way it works.
Okay, wait,
I didn't believe that there was an issue about that,
On the
Your Honor.
expert,
And the court, the trial court made it very clear that Dr. Eichler was not going to be allowed to testify with respect to anything that occurred on March 30th, March 31st of 2014.
All right, so you knew that already when you said he approved. That was pretrial.
Based
So
on
you
Dr.
knew
Giblin's
already,
testimony.
and your opening is Dr. Eichler approved. And then a bunch of your witnesses say, one says, essentially, Dr. Eichler approved, or I worked with Dr. Eichler, or I would never have done this without his approval, you know, things like that. And then an expert says, that's how it works. The attending does X, and the resident does Y, and maybe, and Giblin, I suppose, says that as well. All right, that's different from having him come on the stand and say what his practice is. You know, people usually do that, but since my drinking problem started, I just don't do it anymore. Or, oh, that month, God, I think I was in Cannes, you know, the film festival is that month, and I try to keep in touch, but the time zones, right? I mean...
Respectfully, Your Honor, I don't see that that would have significantly added anything.
No, it might have harmed your
defense.
case, actually, to have him on the stand, right?
Right, but
Well, I think, Your Honor, I think his custom and practice, as we know from the deposition, and this is the point, Your Honor, the court had his deposition. It was part of the record.
You did too?
Yes, I have, of course I had it. But the trial court had it. The trial court knew that his testimony was not going to be unfavorable to the defense. She knew that.
Oh,
The
I think
court
it's
knew that
incredibly
from the-
unfavorable to the defense.
Excuse me?
I think it's incredibly unfavorable to the defense.
Well, I disagree.
Once you say he approved of it, and you put him on the stand, and he never says, I approved of it.
Well, he says he has no memory. He doesn't say he approved it. He can't say because he has no memory. But what he...
Okay, but you said he approved it.
Based on Dr. Giblin's testimony, Your Honor, and based on Dr. Eichler's deposition
But
testimony...
don't you think that would have been undermined by him not remembering it?
No, I don't, Your Honor. Your Honor, he was deposed...
If he could say, I approved, that would help your case a lot. But he can't.
But, Your Honor, he would have said, it would have been my custom and practice to have done that, and that was in his deposition. I didn't feel that that warranted bringing him in, putting him on the stand.
Well, it's not,
we can disagree,
I mean,
Your
look,
Honor, and
lawyers have lots of reasons for not putting someone on the stand, particularly after the judge said, if you don't bring him in, I'm going to have to consider a missing witness instruction, which I understand the judge, sua sponte, said, whatever. But once the judge said that, you knew that the risk of not bringing him in the next day or the day after, there were still a couple days, I think, left in the trial.
call me stupid, whatever.
No, I'm not.
Your Honor, the judge said that. We then filed, after the judge said it, of course, it went back, read the case law, looked at the cases. We filed a bench memorandum. It was inconceivable to me that the court would give a missing witness instruction in this case. Again, you can, call me stupid, whatever.
Well,
it was based on Alves, based on Anderson, based on Hoffman. I just couldn't see how.
Did you ask the judge to rule on that motion, and then if he still concluded, you were certain, but if he still concluded that he would give the missing witness instruction, then you'd bring the doctor in? Did you say that in advance of, or did you, either in advance of your bench memorandum or right at the time that he said that? We're sure you're wrong, Your Honor. Can we file a brief on that before we decide if we have to bring him in?
No, we filed the bench memorandum, and then the issue was not revisited again until the charge conference. And
can we go back to the 4 factors for a missing witness instruction, the doctrine, and your reliance on cumulativeness? I want to focus on something concrete, cumulative. You introduced this concept. Dr. Giblin will testify that her supervisor was the one who decided. That's a credibility question, and it can't, his testimony on that question about a conversation they had where she's testifying about something to save her bacon, that's obviously a self-interested statement. I think you even conceded this in your brief. That is a obvious, basic credibility question. His testimony about that conversation can't possibly be cumulative. What he says actually happened can't possibly be cumulative. And the expert can't possibly speak to that because he wasn't there. The question is factually, how did that conversation go? And the fact that he's already testified in a deposition how that conversation went doesn't answer the question for the jury because, as you know, that deposition didn't come in. What's your answer to that this is cumulative?
Again, the only thing that Dr. Eichler was going to be allowed to testify to was his custom and practice. The court made it very clear that he wasn't going to be allowed to testify about any of the events of March 31st. He was not going to be able to say, I remember this discussion with Dr. Giblin, because he didn't.
But he would have verified the custom and practice, that what her testimony was accurate, that the custom and practice was for her to make a recommendation or state what she would do, and then he, the instructor, would either agree with that or give her a different instruction, correct?
He would have testified to that custom and practice, but...
And he was fully aligned with the defendants, correct, in terms of your ability to call him?
I don't know what Your Honor means by fully aligned.
Under the
Hoffman case, we're not allowed to speak to treating physicians, Your Honor. Dr. Eichler was represented by counsel. Dr. Eichler was deposed. I cannot have any outside, if you will, contact with Dr. Eichler.
He continued to work for one of your clients.
No, he wasn't fully aligned.
He wasn't fully aligned.
Well, I'm saying I can't
Based on the deposition testimony.
Excuse me?
Based on the deposition testimony. You're the one saying you know what he was going to say. And what you know he was going to say was, according to you, was consistent with what Dr. Giblin was going to say.
Correct.
Right, and so it was surprising that you didn't call him.
I completely disagree. He couldn't say anything more than what I think the court is perhaps overlooking or just not giving the same importance as I gave it. The plaintiff's own expert acknowledged that the custom and practice, if you will, was just as Dr. Giblin had said, just as our expert, Dr. Peters, later said, and I thought that was very powerful testimony for us.
That's not testimony of what Dr. Eichler's custom and practice was, because they've never met him. Do you see? It's at least not cumulative. It's generally what goes on versus that's what I do. Seems like two separate things, and it does seem surprising. Why not bring?
Well, I guess it's partially a question of what world you live in, Your Honor. In the world of academic medicine, this is pretty cut and dried. This is how it works in every single major tertiary care hospital across the country. This is not, Mass
I get what you're saying,
that Brigham does it another way.
The resident goes to the attending and the attending gives the orders. That's how the custom and practice works. But I have a different custom and practice. Is it your custom and practice, Dr. Eichler, to give 25 milligrams to a 60-year-old, a 60-pounder who's 13, where the FDA regs are that if she were 12, you would consider her weight and you would give her 5 milligrams. So in other words, you're giving 5 times because of this tiny little difference. Would you have factored that in your custom? I know you don't remember what happened in this case because it was 11 years ago, but would you factor that in your considerable experience? That seems to me like a very dangerous question that you might have wanted to avoid.
No, I didn't want to avoid it. In fact, the fact that the court made it very clear, the trial court made it very clear that I was not going to be allowed to ask Dr. Eichler any if questions, okay, because he didn't have any memory, and the court made it clear I wasn't going to be able to say to him.
We understand the scope of that limitation, and we're over time. So thank you very much. Very helpful argument. We will hear
thank you, Your Honors.
next from Attorney, I'm going to guess Attorney Lynette.
Absolutely. And good afternoon, Your Honors. My name is Christopher Lynette. I'm representing the plaintiff. We're the appellee here, NELSY Juarez. And we're asking that you affirm the judgment below because there was no abuse of discretion. Dr. Eckler was called the final decision maker in defendant's opening. And I'm going to just quote, it's at RA 3503. They agreed, Dr. Eckler and Dr. Giblin. That's on the next page. What Dr. Eckler approved is is 2 pages later. That's an opening. That's not saying there's going to be evidence from which you can draw those conclusions. You're going to hear about this final decision maker. What he said was a board-certified pediatric neurologist you're going to hear about. And then throughout trial, we don't see this person. We hear a junior resident who did a brief rotation in the pediatric neurology department, and then two third-party experts. And the trial court, after hearing this opening, after hearing Dr. Giblin testify for 2 days, it was after her second day of testimony, looks to my brother, defense counsel, now my opponent, and says, are you going to call Dr. Eckler or I have to do a missing witness here? There's no case, by the way, where a judge has given the party the opportunity to get out of the missing witness instruction. I haven't found a case like that. So you have a new procedural safeguard, which is great.
Yeah, but I think he has a different take on it, which is that the judge really abandoned their role as a neutral, and they should have let you ask for that, and they didn't. I mean, I don't know that it rises to appellate argument, but that's the implication.
Absolutely, Your Honor. But what you have to understand is the judge is watching this in real time and is watching this case as being presented. First of all, abuse of discretion, all the procedural safeguards are there. Every one that the SJC and this court has outlined occurred. Mid-trial, written briefing, a colloquy, a thorough colloquy actually, and even an opportunity to call the witness and avoid the instruction. That was all foregone. And we have—
Should they have been given an opportunity after losing this motion to then call the witness? Right, because the alternative is, we really think we don't have to call this witness. Now, I suppose part of the answer might be, well, if it's so harmless to you, why not exactly? Why not bring the person in rather than running this risk? And maybe that is an adequate answer. But if they think, look, we really don't want to do this, maybe, I mean, I wasn't at the trial. The jurors look really bored. I want to wrap this thing up as quick as I can. I feel like we're losing them, whatever. No one has said that, and that wasn't the plausible reason given, allegedly plausible reason given, and so on. So they really don't want to do it, but it's not because it's a damaging witness. So they go and they have the argument about it.
Absolutely.
And then they lose. And then should they have an opportunity to be like, well, we're going to bore them, but okay, let's, it's better than this instruction.
So I'm just trying to understand your hypothetical, Your Honor. So the judge makes a ruling, and then after that ruling after all of this, tells the party, do you want to call them or I'm going to give the instruction? So basically there's a ruling, and then there's a relief valve.
Yeah.
Well, I don't know. I haven't run across a case that would say that there's a relief valve, but that would actually destroy the instruction, Your Honor. I think it would allow a party to know the consequence and play chicken with the judge. I'm not going to call the witness. Let me see if the judge is going to rule against me, and then if they do, I could get out of it. I don't think that that's what we encourage.
And usually the instruction is just given with no advance warning.
Yes, it's usually given.
That is, at the charge conference to go through it, and presumably you would have to request it, or maybe not. Judges sua sponte do things in instructions all the time, I guess.
Absolutely, Your Honor. But that's what you did have is essentially an escape valve in this case. If you look at the judge's comments, she was very concerned about this testimony coming in. And the proffered reason here, counsel's argument for reversal is that if an attorney comes up with any reason, that's what they say in their brief, the instruction must not be given when the opposing party proffers. That's all it requires, a proffer of some excuse. That's it. That's not the rule in Massachusetts. There's a balancing between the importance of the witness and the context of the case. And as Your Honors have highlighted, Dr. Eckler, as the defendants have said, is the decision maker. He's the second part of this conversation that is critical. And for some reason, they chose not to put him on the stand, even though he has all the credentials. And in fact, Dr. Giblin, at Record Appendix 388, said, I can't even prescribe this stuff. Eckler has to sign off on it for me. So what we really have is a strange presentation of a case. And then, I think this is really the kicker, they ask to find against the plaintiff based on his medical judgment, and the jury never gets to lay an eye on it. I think on those facts, it is not an abuse of discretion to issue a neutral, non-naming missing witness charge. And that's the basis of our case, Your Honors. We lay it out in our brief, but we don't have, 3 of the 4 factors are not contested on appeal. Let's be clear about that. The only factor that is contested is counsel's reason. And we essentially have cumulativeness, but there's plenty that Dr. Eckler could have offered. In fact, he probably should have been the main witness, and Giblin should have backed him up. But that's not how counsel chose to present the case. I don't know why.
Well, even if he would have backed her up to some extent, and even though he hasn't been joined in the case, frequently people don't like, if they see some terrible outcome like this, to take responsibility for it. So who knows how his demeanor would have been, or
Exactly.
I don't know anything about that.
And this is about, to Justice Wood, you mentioned this, is about that credibility determination. What essentially they presented is one half of a conversation, and then an expert to comment how those conversations usually go. That's an odd way to present a case when you're saying that this is the other guy on the other end of the phone who you're not going to hear from is the decision maker.
Well, I mean, to play devil's advocate with myself,
Absolutely.
are you, I mean, my first reading of all this, the defense makes a very clear common sense argument that he didn't remember. It was 11 years ago. You look at his deposition testimony, he says the same thing. So their view is, with a tired jury that's heard a lot of stuff, that all he's going to say is, I don't remember. It was 11 years ago. What did I normally do? Yeah, the residents came to me. Why is that not a good enough reason?
Well, I think that, first of all, that could be applied to any case. I don't think that's really...
Sorry, that could be...
I think that could go in any case. An attorney could say, well, that's just an extra witness. I don't need them. I've already proved my case. I think what you're talking about is the trial court watching these proceedings and trying to protect the jury, trying to understand who are the critical players here. And this is what Rollins said. I think Rollins is on all fours here, by the way, Your Honors. That was a case where a defendant got on the stand and testified about, he basically proffered an alibi, and he put up one alibi witness but not the second. And when defense was asked, why aren't you going to produce the second witness to corroborate, this conversation? They said, well, he's busy and it'd be cumulative. And the trial court said, well, those excuses aren't good enough on this facts when you need that cooperation. And Rollins said that's good. And I think Rollins is on all fours with this case.
Wait, sorry, but Rollins was a criminal case.
He was, correct.
Yeah, and so there's no deposition. We know here, we have evidence from the deposition of what we expect that Dr. Eichler is going to say. He's going to say, and it's combined with common sense, that he's going to say, it was 11 years ago, I don't remember. I don't remember this patient, I just don't remember.
Although they may not even be allowed to ask him that question, given the weird limiting
right.
thing
there was a weird
that
limitation.
the judge...
Right. It's plausible that's the point. On these facts, it's plausible. It's not crazy to say he just wouldn't give any useful information.
I disagree with that, Your Honor,
Okay,
because
why?
as you've outlined is that this is about, first of all, the first person you have testified is a junior resident. They did a brief rotation through the Mass General Hospital, so they're only talking about...
Dr. Giblin, we're talking about
Dr. Giblin,
yeah,
I'm sorry.
right, the defendant,
Thank you for correcting me. That person is talking only about a limited period of time in that neurology unit and her experience there. When you have Dr. Eckler, who is the according to counsel, the board-certified 11 years experience attending physician final decision maker. It strikes me as that on those two facts, when you have somebody who's a participant in a limited period of time about those procedures, that Dr. Eckler, the person who's versed in it, who has years of experience, can give additional relevant information about that. And that is certainly a reason to put him on the stand.
Well, all they say is cumulative.
That's all. That's the only...
They don't say tired jury.
No,
they don't say, yeah, it'd be great, but there's all these externalities to this, and so we're not. They just say cumulative. And I just don't understand how the person's own testimony about what their practice is cumulative of what the generic practice is, and for the reasons that Judge Wood put out, is cumulative of what the self-interested defendant said.
And absolutely. And just briefly,
I think one concern, though, is did the plaintiff's closing go too far on the missing witness? Because you knew what his deposition testimony was. Do you agree his testimony was basically, this was our practice? Even I don't remember the specifics,
I can't tell you one way or another, but it would have been my practice.
Right.
That's right.
And in the closing, it says you're supposed to take their word for it, how it works at Mass General, and not the pediatric neurologist, Dr. Eichler, who still works there. sort of somehow implying that maybe that wasn't going to be what the testimony would be.
Well, Your Honor, I think that's a piece of I don't know if that part of the closing
Was there an
included.
objection to that?
I don't think there was an objection to that, first of all. And the other part is that I just want to note, the line counsel complains about is if he approved the plan, why isn't he here telling you so? Here's what defense counsel said in his closing. Is the plaintiff saying that Dr. Giblin didn't speak to Dr. Eckler? Is the plaintiff saying that Dr. Eckler didn't approve the plan? Defense can't ask those questions and then leave them hanging and then not object to our answer and then claim appellate error. And that's what we're saying, Your Honor, is that largely, I think the argument,
But in a civil case, no objection means we're done, right? There's no substantial risk
no, Your
of
Honor,
a...
that's right. And so I'm hearing the bench quiet down, so unless there's any further questions.
It's a weird thing for this bench. I'm done.
Yeah, this bench is very bad at actually
Your Honor,
staying within the time limits, but
there are two people who helped me in this case who aren't on the briefs, but they're my two law clerks back in Pennsylvania, Justice Morey and Elizabeth Schultz. They both work for our firm. They're at Villanova Law School. They didn't get on the record, but I want to thank them so they know that their effort and help.
What's the first name of the first one?
Justice Morey. I know. I think he's got to be a DA or something in the future.
Justice. Because then they could be
then-
Justice Morey one day.
The last remark I will make is that the last time I was in this room, I was a student at Suffolk University Law School doing an argument.
Welcome
This is my
back.
first time back, so thank you so
Welcome back
much.
to
We
everyone
ask that you
who's been
affirm.
here before. Thank you very much. Very helpful arguments from both sides. The case is submitted. This brings us to the final case of the morning. This is number 25-235. And it is captioned City of Malden versus Bruce Friedman doing business as opencommonwealth.org. And Mr. Friedman, I'll say to you, as I said to the other pro se litigants we've heard this morning, though perhaps you are not easily intimidated, this may be intimidating and difficult. You're not trained as a lawyer, so far as I know, so we will try to make this as, functionally easy for you as possible. With that, we will hear your argument.
Good afternoon, members of the panel. May it please the court. My name is Bruce Friedman. I'm pro se. I am a citizen journalist as defined by the Supreme Court of Massachusetts, and I am here to represent people who are looking for transparency, public records, open meeting law type of issues as citizens, as journalists. I don't think we could be in a more complicated time politically in this world where these things are very important. These are cases of first impression.
Sir, how
in
many
Massachusetts.
public records requests have you made to the city of Malden?
In excess of 200. I do think it's also important that I call the attention of this court to an incident that took place on January 27th, 2026. It has not been supplemented in the record.
Well, then maybe you shouldn't draw our attention to it if it's not in the record.
Well, it just happened 2 weeks ago. So I would be
Okay,
happy to
but how,
supplement the record.
it can't have any bearing on your appeal because we're reviewing stuff that happened.
Okay.
Okay.
The genesis of my road here began with a public records request as part of a process to unearth what happened to my child who is severely disabled on his transportation to school. That particular case still exists today. It is the fourth case. I've been sued 4 times by the city of Malden to prevent the release of records that were all ordered released by the supervisor of public records. I think it's really important that this court understand the 59H that took place in these 3 cases should have happened in the first case, but did not, under the advice of counsel.
So wait. Do these 3 cases involve that information or other information?
They're all basically the same case, Your Honor. They are each individual public records requests that are separate from each other, but
they all relate to the condition of your child?
No.
Oh, they don't? Yeah, that's what I'm asking, whether it's the same.
I think what the city might say is that they don't agree with some decisions by the supervisor of public records and that they are trying to challenge a couple of those decisions, and you are really kind of in the rocking chair, and you could have just sat back and let the two governmental entities fight it out until there was an interpretation.
Your Honor, if the courts would just simply follow the public records law, which is more specific and very clear on this, they have no injury. We've talked about injury this morning in other cases. The city of Malden cannot prove any injury upon them
Well, it's
whatsoever.
saying that it lost the ability to charge you an hourly fee,
They
correct?
do not have to produce the records, Your Honor. The supervisor of public records has no authority to enforce their orders. There has never been, in this case, any adjudicatory process. There has not been a single sworn process, statement, affidavit. There has not been any ability for me to cross-examine anybody. This is simply the words they write are what's being.
No, if they didn't produce the documents, then you would have filed a lawsuit
And
against
in
them.
that case, the law provides that they get a de novo review. Today, the review that they're proposing under 30A in one case or under cert gives them only arbitrary and capricious.
So I want to ask you more about what you just said, because certiorari is only available if there's no other mechanism for review. And I read with some care sections 10 and 10A of Chapter 66. And it is true and interesting to me, not only that any aggrieved party may not appeal from at least under the statute, may not appeal from the supervisor, only the requester can. But then it also says, if the record keeper does not release the records pursuant to a supervisor's order, it says the supervisor may inform the Attorney General, who may take whatever action she deems whatever appropriate. Do you believe that you can also sue?
Yes, I believe that I can sue, and I believe the Attorney General can sue.
And you can sue how?
Under the public records law.
And would you be seeking mandamus, or what exactly? Or the public records law just says if you don't follow?
To enforce the supervisor's orders.
Yes.
Or I could sue the supervisor saying that the supervisor did not correctly interpret the case.
No, I understand you can appeal if the supervisor goes against you, but this is a case where the supervisor ruled for you.
Yes.
And so they're supposed to, within 20 days or some quite short time period, I may have that wrong because there's some little additions going on, but it's never more than 40 days, even if you add everything together. They have to release the documents. This suggests that they may not. The statute itself says maybe they won't release them even though they've been ordered to. And then you have to sue them.
Either me or the Attorney General,
Okay.
correct.
And my sense is, maybe you even said this, the Attorney General doesn't do this much.
Correct.
Okay, so maybe it's you or another requestor. In the meantime, until you win, you don't get the documents.
Correct.
Because I thought one of your most powerful arguments about this not being a proper certiorari action is surely they can't go in. They only had 40 days and have a multi-year-long case without releasing the documents.
Correct.
But wouldn't they get that same result if you were the one to bring suit? Wouldn't they say, okay, we're not releasing this until the court orders us to, and we're going to defend on the ground that the supervisor made a mistake?
I'm not sure I understand the differentiation you're making.
If you bring the suit, you still don't have the documents.
Correct.
And you want them because you asked for them, and the supervisor says you're entitled to them. So can they defend your lawsuit by saying the supervisor was wrong?
Yes. Yes. Again, if I sue or the Attorney General sues, they enjoy the de novo standard. That's what the law calls for under the public records law. That's why, again, 30A or cert is an end run around the public records law.
So
if that was just what was applied here, we would never need 50
Now, of course, there is one thing that they ask for in their suit that they wouldn't get if they won your suit. They ask to enjoin you from making public record requests.
Correct.
So far as I can tell, that's the only thing, and the statute does not provide for that kind of injunction, obviously. I'm just trying to figure out why they didn't just withhold it. Are there costs associated with that? Is there some reason they don't have to pay your costs or something if they lose?
If I win on a case that I bring and the supervisor ordered in my favor in that case, they are statutorily required to pay attorney's fees, correct?
Okay.
But you don't have an attorney, so.
Not have an attorney.
No, you might still be able to get reasonable fees. There's rules about pro se. I don't know what they are.
Certainly the cost of filing those things I could ask
Sure.
for, but not my time, which is obviously the main expense here.
Mm-hmm.
I think that you've drawn the attention to the most important factor of why this has happened. This is about silencing me. This is about making, today, if I file a public records request to the city of Malden, they will not respond. I will go to the supervisor of public records, and the supervisor will say, I can't opine on this because we're enjoined in litigation that's 4 years old. They have effectively prevented me.
Wait. Because of this litigation,
Yes.
the supervisor will no longer rule on your requests?
On a completely separate public records request that has nothing to do with any of these cases.
Well, where does the supervisor get the authority to not rule?
She says she cannot opine. Her interpretation of the public records law today is that she is barred from making a determination, from opining on a case while we are in litigation.
Is she an appellee in this case or an appellant?
She is neither. She is a third party in this case.
How
Did she ever get, did she or the Secretary of the Commonwealth ever get served?
Yes. Yes, absolutely.
I thought they made an appearance here. There's a lawyer listed
made
on the
an appearance
docket. And they didn't say we're filing a brief or not filing a brief?
They decided not to file a brief.
Did
And
they file something here saying they would not be filing a brief?
I do not believe so, but I will tell you that.
Isn't this really their case to,
Well, no, Your Honor, because this affects my rights.
No, of course, I agree with that.
I think.
Right, but they're saying the basis that they don't want to give you the documents is this, or their rights differ is, in some of the cases, or one of the cases, it's what the definition of a business day is, and in a different case, it's what harassment is. And if they don't include you, then they would have to give you the documents.
You're a
And if they
necessary-
do, right, so that's why you're here, and you could be sitting back and letting the two governmental entities fight it out.
Except for they are looking to ban me permanently from making public records.
Oh, eventually you would have to fight, but in terms of they're saying there are non-petitioning reasons that don't have to do with you, that have to do with interpretation of the public records law.
So again, without my request and without my appeals to the supervisor of public records, there's nothing to debate here. The genesis of this case is 100% about my requests and about my appeals to the supervisor of public records and her ordering them to produce the records. Again, at the end of the day, if they do nothing, they simply just say, dial tone to Mr. Friedman, I am not going to give him anything. Nothing happens until such time as where I sue them or the Attorney General sues them, and at that point in time, they get de novo review. And it's provided for in the public records law. This is an end run around public records law. It is specifically designed to silence me. And the 59H would not be necessary, again, if we just followed the public records law. But both judges in both cases that have heard this have indicated that this is protected petitioning activity, yet they didn't dispose of the parts of the case where protected petitioning activity was done. And I understand that they feel conflicted because they believe that they should have a right to have an adverse decision made by the supervisor of public records heard, but they have no injury. They have if they do nothing, the only thing they can say is, well, we have an order against us from the supervisor of public records.
So you're saying that if this went away, and you then did decide to file a lawsuit on one of these claims, you wouldn't turn around and say they were barred from making certain arguments because this case went away?
I would have no right to do that. I would have no right to, again, this would be a de novo review of what was presented to the supervisor of public records, and the court would have the duty.
So if we
of the supervisor of public records interpretation of what a business day was and what harassment is?
Yes.
And is it your position?
And harassment, by the way,
that we could remand and order the court to dismiss their certiorari action and make clear that it's not on the merits, so that you could bring a lawsuit.
I have. There's counterclaims filed in every case.
You say that again?
There's counterclaims filed in every case, Your Honor.
But it's in the certiorari action.
There are counterclaims filed. They filed under three theories. They filed under cert, they filed under 30A, and they filed under harassment.
Okay.
So then if you're counterclaiming, what are we arguing about? I know that this is not, we don't like to engage in empty gestures. If you're counterclaiming and so now you feel you've brought suit, or are you saying we could also dismiss your counterclaims?
My counterclaims are designed to get the records, Your Honor. Their case is
Right,
designed
I
to
know,
silence
but we
me.
don't do things as an academic exercise. This might be a surprise to you, but we have a lot of work, okay? So if you are intending to sue them anyway, what are we arguing about here? Why are we here?
Because what has happened is that they have abused the public records law and created case law at the lower court that the supervisor of public records will adhere to that says that I have harassed them and that they are subject to.
Well, sir, if every citizen of Malden filed 200 public records requests, do you think that the city could function?
I am not the most prolific public records.
Shouldn't the legislature deal with that? You have a right to bring these requests. As many as you want, so far as I can tell from the statute.
Correct. And harassment is defined very well in the codification of the public records law.
And the remedy for that, is, if harassment is found by the supervisor, is that request doesn't have to be responded to. It doesn't label you or any other citizen a harasser unable to take advantage of the statute. And if the legislature thinks it should, they can fix that.
Correct. And again, this is a case where they have sued and have interrupted my ability to make further public records requests. They've ensnared me in a case that is well over 4 years old, Your Honor. And I am an individual, and they should not be allowed
but sir,
to.
You're
the chilling
saying,
effect of if they are allowed to sue, the chilling effect upon public records.
If I understand you correctly, you are saying that you would have, and you now have, in this case by counterclaim, but that you would have sued to enforce.
No.
You're not saying that.
No, I'm
Okay.
not saying that, and no, I didn't do that. As a matter of fact, I have never sued the city of Malden. I have sued state agencies and won, and been in front of a panel on that particular case.
Wait, so you're actually, like your brief says, you're asking us to dismiss this action. Your
Correct.
counterclaims won't survive. The whole thing will be gone.
Correct.
Yeah, okay.
And at that point in time, then my ability to move forward and sue them, and they would have a de novo review, proceeds. The question is, do they have the legal ability to sue a public records requester?
Right, but
And if
he's going to get up in a minute, or she, I can't tell, my glasses are terrible, and they're going to say that, I got distracted, it'll come back to me.
they are allowed to do this, the chilling effect on people making public records requests could not be more clear. If I file a request they don't like, or for records they don't want to release, they just simply sue me. And you say, what about 200 people? How many other people are out here making case law on public records? I'm sorry, but there's not enough. If I was the Boston Globe represented by Jeffrey Pyle, I would not be at this table, I would be at this table, Your Honor. And I think that's one of the problems, and one of the responsibilities of this court is to uphold the law for the people who are doing this work. And today, journalism is under attack. The Globe is not what it was. The Washington Post is clearly not what it was. And most of the work that's being done today is by people like me.
So he's going to get up in a minute, and he's going to say the arguments you're making right now are motion to dismiss arguments. They're not anti-SLAPP arguments, and that we can't, those are not properly before us. So what's your response to that?
That I was performing protected petitioning activity, and they are trying to stop me from doing that, and that is the very definition of 59H, period. This would not be necessary if the court properly interpreted.
You can continue to make public records requests, and if the Secretary of State or their employee is making a wrong decision, that's not on them, that's on...
They're refusing to hear, no, I will make a request, they won't respond, I will go to the Secretary, say they didn't respond, and they will say, we can't do anything about it because you're in litigation.
Right, but then all they're doing is they're playing the same, game of working the system, and if the supervisor of public records is making a decision that's unlawful, then it's up to you to challenge that, and they're taking advantage of it.
Your Honor, it's not a game. This is about the inner workings of our government. This is how they spend our money.
I know it's not a game. I'm using game in the sense of playing every rule and every little nuance in your favor. You're doing that. They're playing every little nuance and every little tactic in their favor.
I couldn't disagree with you more. I'm making public records requests, and they're not providing the documents that not only I believe they should, but as the supervisor of public records.
Okay,
believes they
but their response is going to be in just a minute that they're going to say they're trying to get a definition of harassment and they're trying to get a definition of business day. And it happens to be that you're the person who's asking for it and that they're entitled to get that definition.
Okay, well,
They have it. The Attorney General has given it to them. And she is the authority on this. And they are, the definition of harassment couldn't be more clear. They're not asking for a definition of harassment. They're actually asking for you to do something that is clearly not in the law. They're asking for you to permanently, they're asked the lower court to permanently ban me from being able to make further public records requests from their city.
I think we understand.
do you? Are you? Okay. Your time has expired. Thank you very much.
Thank you.
It's an important case and interesting, and that was helpful to us. And now we will hear from Attorney Donnelly.
Yes, good afternoon, Your Honors. May it please the Court, James Donnelly for the City of Malden. So, Justice Henry, as you alluded to, I think the sole issue really for this appeal is a question of how the anti-SLAPP law applies to this immediate context, meaning where there's a public records custodian who is seeking judicial or certiorari review of an administrative agency decision from the supervisor of records. And under that analysis, the sole thing to look at is the Bristol asphalt test, and specifically stage 1, question 2 of that test, which asks not where did the claim originate. It asks, is there any substantial basis for the claim other than the legitimate?
All right, so
But
let's.
I'm understanding that you're saying that as to the propriety of your causes of action, whether it's certiorari review, judicial review of administrative agency decision, or declaratory judgment, your position is those issues are not properly before us. All we're here to decide is the anti-SLAPP motion, correct?
Correct.
But if you can't bring a certiorari action, then there's no substantial basis for your lawsuit, right?
So I think as part of the trial judge's decisions, they didn't explicitly rule on that point, but that's, I guess, an assumption, or that underpins.
Okay, so let's look at that assumption for a minute. The statute doesn't give you a right to appeal, right?
I would disagree, Your Honor.
You wrote in your brief that you have no avenue of appeal aside from this. If you have an avenue of appeal, then we shouldn't be doing a certiorari action,
Correct.
and there's no substantial basis for your suit.
Once there's a supervisor of records determination, there's no further avenue for appeal.
Okay. That's deliberate, clearly, because instead of writing any person aggrieved by a decision of the supervisor may appeal, the legislature wrote a requestor may appeal, right?
Okay.
Okay, I don't know where this lands with respect to certiorari, but they deliberately didn't give you a right to appeal from that. They did say in 10A, if you don't comply, then the Attorney General could bring an enforcement action, which to me suggests if you want to get this reviewed, don't comply, and then maybe you'll get an enforcement action. It also says that any violation of the law can be challenged in a Suffolk Superior Court action by the requestor. So maybe if you don't reply, don't follow what the supervisor said, you'll get that kind of suit. Seems to me that that's how the legislature wants these things reviewed, if at all. And if you don't get those suits, then you don't, and you still haven't complied with the request, notwithstanding the supervisor order. I don't understand why you need to bring a certiorari action, particularly when the legislature clearly didn't give you a right to appeal from these supervisor decisions.
Can we break that down? Do you agree they didn't give you a right to appeal?
So within the public records statute, there's no explicit language.
And you said in your brief that there is no, is there another right to appeal?
Certiorari.
That's not an appeal, that's an action in the nature of certiorari when there is no right to appeal.
Right.
Okay, so we're in agreement, there's no right to appeal. You're saying you can bring certiorari.
Correct.
And I'm saying What if the alternative avenue set up by the legislature is don't comply?
So,
And if someone sues to enforce it, then you can say, but it's an illegal and wrong order.
so let me just speak to that point a little bit. The way the public records law is designed, right, is so that the sole tool that public records custodians have, if they get a request where there's 1 million responsive records, right, the sole tool that public records custodians have to address that request is to give a fee estimate within 10 business days.
Yeah.
Right? If they miss that deadline, you're out of luck.
Okay, and the supervisor says you missed it.
Right. Which is why it's so important for us.
Well, I certainly agree that you cannot comply with the order because it's too expensive. And if someone sues to get you to enforce it, either the Attorney General or the requester, your defense will be that the supervisor made an error. He doesn't know how to count, or she actually doesn't know how to count. Why isn't that your remedy? Why do you get to come into court and sue a requester, forcing the requestor, who is just a member of the public? There's no provision for suing a requester. They're just people asking for a record. Now he's going to be in court, and I think we'll probably agree that he's a necessary party to this. At least, well, all of them really.
Can we get an answer to?
Yeah, so go ahead.
Well, so the consequence of us sitting back, not responding, letting either the public records requester or the AG, who, if the AG brings it, I'm not sure if it would be de novo review. But in any case, if they bring that case and we lose, right, then if the public records requester brought it, we have to pay fees. Okay?
So you should think very hard before you decide not to comply. Just like businesses do when they face fees for a 93A claim. They have to think very hard about whether they should do X or Y.
Agreed.
So you also, maybe deliberately.
Sorry, but wait, can I recast that? The question originally was, why can you sue? That seems like a good, simple, concrete question. I think you were just saying, we need to be able to sue because otherwise we're going to be facing these big fees. Is that what you're saying?
Yes, we need...
Why should we care about you facing big fees if it's a public record request? I think that's the... Why is that a good answer?
We need the option to pursue certiorari review, because without it, we could be stuck with a determination from the supervisor of records that is clearly erroneous and which burdens the city with potentially unlimited costs.
Right, but is that a question for us, or is that a question for the legislature?
So, yeah, it's a question for the legislature. That's the way the public records law is set up, right?
Right, so they've made a decision. I mean, I don't know that you're conceding this, but there's certainly an argument that they've made a decision for what the balance is about responding and not responding, and how you can make an argument with the supervisor of public records determination. That's the decision they've made.
Well, so the legislature has also set up certiorari review, right? It's not, they just set up the public records law and that's it. They've also set up certiorari review so that municipalities can...
No, I don't know if that's right. They set it up so that people with constitutional rights could. You don't have any. So I'm not sure. I'm trying to think of times I've seen a city seek certiorari review. Maybe it happens in civil service cases or something. I don't know.
It happens all the time when there's administrative agency decisions involving a public entity on one side, and it could be anyone on the other side. It could be public records requester. It could be a company represented by a law firm.
And the city brings certiorari actions against the state.
Correct. To obtain review of what the public entity thinks is a clearly arbitrary determination.
Final judicial action by an agency.
Say that one more time.
Final judicial or quasi-judicial action by an agency.
Yes.
I'm not sure that's what this is.
Right, but do you have a case, that a precedential appellate decision that provides authorization to use the certiorari this way?
So not in the public records context.
Okay.
There's, well, not an appellate level case.
Okay.
At the trial level, in the Malden Public Schools case, the judge opined there that we could. And I should say the supervisor of records agrees that certiorari.
I don't know what the supervisor of records thinks. For some reason, they haven't appeared here. I'm baffled by this. I would think this would affect them enormously, and the fact they don't care enough to come in is really surprising to me. But that's just editorial, I guess.
So I want to make sure that I understand your arguments about the non-petitioning activities that you say are at play. And I think what you're saying is you're looking for a definition of business day and a definition of harassment, and you've got some allegations that are outside his request for records, right?
Correct.
Is there anything else?
No.
I missed anything? Okay. And you, okay, and you've covered why it's harmful for you to wait for him to sue you, because you then run a risk of paying attorney's fees, assuming he can get an attorney who will represent him.
And we would be stuck with, if we lose the case, the costs of that production. We wouldn't be able to charge.
Yes, but if the supervisor's right, you are stuck. Right? That's just another way of saying if the supervisor's right, we lose, and we didn't get it in time. Well, of course you're stuck with the cost then, because you didn't get it in time. But if you got it in time, then, right, if you win, then you win.
Right, why would that be unfair? Right, why would that such a ruling be unfair? If you have 10 days, the rules are the rules, you got 10 days to produce these things.
I'm not saying it's unfair. I'm saying that basically that's the consequence. That's why it's so important that we have some avenue available.
You do. Don't respond to the request. As you've said, it's too expensive, and run the risk that you'll lose. All you found is a way to lose without paying fees, right? But the way that you might lose under the statute, you would pay fees. But I just don't see how that's a good enough reason to let a city sue a requestor who doesn't want to be here, doesn't want to pay for a lawyer.
Well,
can I ask you one other question, though? Well, no, answer if that's a question.
Just on that point, at both, in the transcripts of both trial court hearings, we offered to dismiss Mr. Friedman as a party.
And to release the records to him so he wouldn't have to wait till you and the state were done 4 years from now?
So,
is there a stay in place right now?
At the trial court?
Sure. A valid stay that says you don't have to comply with this order. Okay.
So there's three separate trial court dockets here, right?
I want to talk about the harassment one briefly.
Sure.
Do you agree that once the government gave requesters the right to make these requests, they're protected First Amendment activity?
That's what the judges ruled in the trial court below, and we're not appealing that.
Okay. You seek to enjoin him from engaging in protected First Amendment activity. Have you ever heard of a court lawfully issuing a prior restraint on First Amendment activity?
We're not seeking to enjoin First Amendment activity.
Yes, you are.
We're seeking to enjoin harassment.
No, you're seeking to enjoin him from ever filing another request. He already can't file harassing ones. You'll go to the supervisor and not have to comply with them. I'm asking about this idea of enjoining a citizen from making First Amendment protected requests for information from the government. Surely that is a meritless claim.
Well, our argument is that under the public records law, these requests, when you take into account the amount, the frivolous nature of each of them.
Do you get to decide what's frivolous in a public records request?
Well, that's what we're arguing to first the supervisor of records, and when they...
But you're not saying every request he's ever made has been harassment, are you?
maybe not every single one.
Okay, but you want to enjoin every single one going forward.
So that docketed appeal, that refers to 3 10 business days windows where Mr. Friedman requested first 26 extensive public records requests, then 14 extensive public records requests, and then another 2. That's where this originated and why we're seeking to label Mr. Friedman's requests as harassment.
Right, but isn't your protection that you respond, I mean, I get why you might have missed the first 10 business days, but I don't get why you missed it in the second case. Once you knew there was a problem, I don't understand why you didn't change your practice. But in any event, isn't your protection from harassment that you can charge him for really burdensome requests, assuming you check all the boxes, and then if he doesn't have the money, you've got protection? And that's the balance the legislature struck.
Yes, except they also put in the provision about when the requests are intended to harass, the supervisor of records can relieve the municipality from the burden of responding to those requests.
To that request.
So I also am a bit mystified that we do not have someone here arguing. And is he correct that now at this point he's been entirely stymied on any public records request because this case is pending?
So the way the supervisor of records interprets the law or regulations, I think it might be in the regulations actually, is if the request is for records that are subject of pending litigation, then they decline to opine on the request.
So if he asked for records on an entirely different subject than this subject matter, then he would have a chance to get them?
I don't want to speak for the supervisor of records, but yes, that's the way the law is set up. And so I just want to close. We named Mr. Friedman because he was a necessary party. We offered to dismiss him.
If you dismiss him, doesn't the whole suit get dismissed? He's a necessary party.
We offered, if he wished, to dismiss him and continue on with our certiorari review of the supervisor's determinations.
But you
Mr.
wouldn't have to
Friedman-
produce documents in the meantime? Is that but he wouldn't get his documents in the meantime?
Correct, while the litigation is pending and while we're fighting out over the meaning of the words in the law.
See, the problem I have with that is the deadlines are very tight in the statute.
Yes.
Obviously, the legislature wanted very strongly for these things to be quickly turned over to citizens who sought them. If you can sue either him or, frankly, the supervisor in a way that's going to take years without his consent, he's in court for years. He never gets the documents.
Respectfully, I mean, we don't control the length of those lawsuits. In the Malden Public Schools case, we've tried to resolve it, and Mr. Friedman is the one that continues to want to pursue the litigation.
Did he bring that litigation, or is it another one of these certiorari things?
That's another certiorari one, and that involves the Malden Public Schools. It's separate from these 3.
Okay, and was there a 59H motion in that case? No. Okay. All right, we are over time, but if there are more questions, a very complicated case and a very interesting area of law. So thank you very much, both of you, for your helpful assistance through argument.
Thank you, Your Honors.
All right, with that, our session for today comes to a close. I would like to thank the court officers who helped us today, as well as the court staff. And with that, we stand in recess.
Court all rise, please.